Yeah, okay. Hi, if everyone can just get ready, we're ready to start whenever you are. All right, are we ready? Okay. Good morning, everyone. My name is Hedel Desai. I'm the administrative law judge that will be serving as a hearing officer today. Today is March 26th, 2026, and it is a little bit after 9 a.m. We have a number of hearings on the docket today. What I will do is this process is governed by the Walton County Ordinance 25-07. We will generally hear from the county, and then the applicant, if present, will present, and then the presentation of any opposition. I will take public comments at the end of the attorneys and give them time to respond if there is time. Are there any questions from either parties with the first hearing? And if not, we will begin. The first thing on the docket, yes, Ms. Brooke.
Brooke Davis on behalf of the county. No questions from the county perspective. We would ask that, Your Honor,
We've requested to continue item number 4 on the docket, the Johnson RV Park. It's 26-0368, MAJ 25-000037. There's a scheduling conflict with the applicant's representation, and so we'd ask that that be continued until the next quasi-judicial hearing.
Okay, and do you have the date for that hearing? I can pull it up if. Okay,
April 23rd.
Okay, all right, so the Johnson RV Park, which is 26-368, will be continued until April 23rd. And so we only have 3 hearings today. And the first up is 26-0365, the garages at Miramar Phase 1 and 2. And because we don't have pleadings and these kind of proceedings, I'd like to get everybody's appearances for the record. And we'll start with the county and then go to the applicant.
Brooke Davis on behalf of the county, Your Honor.
All right, Mr. Shipman, can you give me just your address so we have it for?
South County Highway 395, Santa Rosa Beach, Florida 32459.
Modern day, we never use addresses, we use email.
We still put the addresses in the final order, so, or the recommended order. So, all right. Let's see. Okay. Again, we're here for the garages at Miramar Phase 1 and 2, and Ms. Davis, if you would like to start.
Yes, Your Honor. First, I would call Mr. Tim Brown to the stand as the project manager on this case.
Okay. And Mr. Brown, I'm going to swear you in. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
And just so you know, we are recording these hearings in the public. Go ahead, Mr. Brown.
All right. Mr. Brown, where do you work?
Walton County Planning and Development,
And how long have you worked there?
almost 18 years.
What's your current job title?
Senior planner,
And how long have you held that job title?
13 years, I believe.
You are AICP certified, is that correct?
Yes,
And you have previously testified in an expert capacity in this forum, is that correct?
yes,
The expertise that you've been qualified as an expert in planning, is that correct?
correct.
Or I'd ask to move Mr. Brown as an expert.
We would stipulate.
Okay. Mr. Brown, I'm going to consider you an expert in planning. Go ahead.
Brown, you're the project manager on this, is that correct?
Yes.
Can you explain to us from a kind of a layman's perspective of what exactly is the garages at Miramar Phase 1 and 2?
It's a storage facility for vehicles, boats, and RVs. And it has a sales center attached to it as well.
And give us just a second, the blurb that you've got, if you can bring that down to a 5,000 foot level instead of 75,000.
Sure. It's a major development order application requesting approval to develop a 49-unit vehicle, boat, and RV storage facility with associated sales center and infrastructure in 2 phases on 9.83 acres with the future land use of mixed use and a zoning of coastal center mixed use.
Right, now, this project in particular, do you know when the county received this application?
I don't think I have that exact date. The first TRC meeting was in December, so it would have came in prior to that, either October or November.
Now, before it went to TRC, did it go to any other meetings?
No, no other meetings.
Okay, so the design review board heard the project after TRC?
Yes,
Okay.
Can I just stop you one there? You're saying October 2025, is that correct?
correct, yes.
Okay.
Either October or November.
Okay, the agenda says the TRC meeting was in 2026, which hasn't happened yet, so I just want to make sure I got
Yeah,
the
it went to
dates right.
TRC on December 3rd, 2025.
Okay, thank you.
So what was the outcome at the technical review committee level?
They approved it by a vote of 6-0 to move it forward to the design review board.
And what did TRC look at on this project?
Well, we look at all the various reviewing agencies' comments and the project overall, and they felt like the comments weren't such that we would have to continue it, so they conditionally approved it and moved it forward to the next level, which would be the design review board.
So technical review committee had some comments about this,
Yes,
and have everything been satisfactorily addressed?
they have.
Now, then it went on to the design review board, you said?
Yes, they approved it by a vote of 6-0 on January 6, 2026, which they're approving the aesthetics of the project. They're not approving the overall project.
And why does the design review board have to look at this project?
Because it's in the US 98 331 scenic corridor. Any projects within that corridor are required to go to the DRB for review and approval.
And then next it went on to planning commission.
Yes.
And what was planning commission's decision?
They voted to approve it by a vote of 5-0 on February 12th, 2026.
And at that level, what are they examining?
They're looking at the overall development in terms of what's around it. Is it appropriate? That kind of thing. They're a recommending body to the county commission. So they're looking at the merits of the project in addition to whether it's compliant with our regulations.
You said that this was zoned as mixed use, is that right?
Coastal Center mixed use, yes.
Are there any special requirements for that zoning district?
No, even though it has a future land use of mixed use, there's actually no mixed use requirement in that zoning district.
Can you explain the access points to this site?
It's going to have one access point off of Highway 98. It's a driveway drive aisle. It's not an actual road. It's just an entrance and exit onto Highway 98.
Are there any improvements required in any other roads in order to make this project compliant with the land development code?
No.
Are there any wetland impacts?
Yes, there are some wetland impacts. Let's see. There's a total of 7.12 acres of wetland. They're impacting 2.09 acres.
Is that allowed under the land development code and comprehensive plan?
Yes, but there's a penalty associated with it. The ISR for those impacted, the impervious surface ratio for those impacted wetlands is 10%.
And does this project meet the code requirements for that impact?
Yes, their ISR's at 33%.
Has the stormwater management system been designed to meet the land development code standards?
Yes,
Does the outflow meet the mosquito control district requirements?
yes. Excuse me, the mosquito control impact requires them to design the 100-year storm, and they have done that.
Will water and sewer serve this site?
Yes, South Walton Utilities has available capacity.
Are there any engineering concerns as to whether there's sufficient infrastructure for these services under our LDC?
No.
Does the LDC require any sidewalk on this?
Yes. However, I believe there's already a sidewalk there with the US 98 widening. But yes, there is a sidewalk requirement.
Is the development located in any kind of a flood zone?
Yeah, the wetlands are in an unnumbered A zone, and the uplands are in an X zone. So they're going to have to follow FEMA requirements for that unnumbered A.
So will a Clomar satisfy the LDC provisions associated with this flood zone?
Based on the conditions from our floodplain manager, yes. Well, both.
Yeah.
First you change it. and then-
Yeah. Are there any environmental concerns?
Yes, since they're impacting wetlands, but those have been mitigated, so there's no outstanding environmental concerns.
And is there any preservation required?
No, there is no preservation on this site.
Are there any other special considerations about this project that we need to consider here today?
No, just the conditions of approval that are in the final order, or recommended final order.
I also, I noticed in reviewing your staff report that parking, there was a requirement for 12 parking spaces, and how many are proposed?
Well, they're proposing 228, but most of those are inside of the units. So each unit will have its own parking. The 12 are associated with the sales center. When you come in, you pull into the sales center. So that's where those park, and based on the sales center, that requires the 12 parking spaces, but each unit will have its own parking inside of that unit.
And they meet all structural height, is that correct?
Yes,
And floor area ratio?
yes.
What about traffic concerns?
That they are, let's see if it's this. Oh, they're generating 10 peak hour trips, which is acceptable on Highway 98. There's no fee involved for that, but they're generating 10 new trips onto Highway 98.
I also noticed that there was a request for a cross-access easement. Is that something that has to be done prior to construction, or does it have to be done prior to the board approving the project?
It typically depends on how Public Works makes the condition. I've seen it both ways. They want the access to be recorded in official records prior to the DO being issued, and I've seen it where they've done it before the certificate of occupancy is issued. But it's a requirement one way or the other. We've consistently required cross-access along Highway 98.
So why is that?
It's a very busy, high-traffic area, and one thing that slows traffic down is curb cuts. So if you do cross-access, you limit the number of curb cuts on the highway, which typically speeds that traffic up, or at least doesn't slow it down more. So almost every project on Highway 98, unless it just goes to wetlands, we're going to require cross-access. And on this one, I'm not quite sure if it's required before the DO or after. Yeah, it says before the final order. So prior to them getting the development order, they're going to have to record this cross-access easement in the official records.
Is that requirement O in the proposed order?
Yes, it is. Well, let me double check. I got the.
Says access roadways shall be 20 feet unobstructed width, 15-foot width is permitted for one-way traffic.
Yes, I'm looking at the staff report, not the final order,
okay.
but it's condition number 3 in the staff report that they have to record that easement prior to the issuance of the final order.
Oh, I see, okay.
Mr. Brown, you prepared a staff report regarding the ins and outs of this project, is that right?
Yes.
And it has some inserts and public comments attached, is that right?
Yes, I'm not sure the public comment got uploaded to the website, but it is in Intergov, and we have hard copies.
I'd ask at this time to move the staff report with the inserts and the public comment that has been received into evidence as the county's Exhibit 1.
Okay, the staff report and the additional information will be included in County 1. I didn't see the public comments, so please make sure that they are
It's listed
Uploaded.
as ALJ public comment in Intergov.
okay. I just am looking at the PDF that's associated with the agenda item.
Yeah, I don't think it got into the project folder. Oh, I included it.
We'll make sure that it's moved into the PDF for the staff report. Or we can do it as an additional,
Why
the
don't we
public
do it-
comment as county's Exhibit 2.
Why don't we
So
do it as Exhibit 2?
Yep.
That way I
Yep.
won't have to look through the 400 pages.
Yep.
Okay.
Okay.
Mr. Brown, you can submit those later.
And have you prepared a proposed final order for this project?
I have,
And did you include conditions of approval for the project?
yes.
And has the applicant voiced any concerns about those conditions of approval?
They have not.
And are those conditions items that you gleaned from compiling your staff report?
Correct.
I don't have anything else from Mr. Brown at this time.
Oh, I'm sorry. There was no public comment for this project. Project Reserves. This project had no public comment. No one came to any of the meetings. There was no one at TRC, no one at DRB, no one at Planning Commission. There's been no public comment whatsoever for this project.
Okay.
So we should just have county's Exhibit number 1 then.
All right. Thank you for clarifying that. Mr. Shipman, do you have questions for this witness? Okay, go ahead.
Mr. Brown, just to kind of summarize, I want to follow up on just a couple items. While there is a traffic study, in the past, we've used that to calculate the mobility fee, or before that, the prop fare share fee. But that has been suspended by the county commission, is that correct?
Correct, yes.
So while we do a traffic study, it really has no bearing on whether or not we meet the comprehensive plan and land development code.
Right, really the only bearing it has now would be for operational improvements, like a turn lane.
Okay. And I just want to summarize real quick. Well, first, everybody likes to use these acronyms, and just for the benefit of the,
ISR, please.
of the judge.
Impervious surface ratio, and I think she mentioned FAR, that's floor area ratio.
Then you also use CLOMAR. Is that conditional letter of map revision?
Yes,
And is that something that's done when you actually start building or before you build?
yes, you build it up, so you're, in this case, it applies to the floodplain, so you're building up that floodplain. So you have to get it amended through FEMA, and the first step is the CLOMAR F, which the F is for fill.
So that's always done after a development order is issued.
Well, afterwards, in this case, they need to do a LOMAR F, so they're gonna have to do both. So the CLOMAR comes first, and then at the end, they do the LOMAR.
And for the judge's benefit.
It's a letter of map amendment, a map revision with fill. Letter of map revision with fill.
So in terms of reviewing, for the purpose of what we're here about today, which is whether or not we meet all the elements, the applicable elements of the comprehensive plan or land development code for Walton County, it was reviewed by first the planning department and its consultants, correct?
Well, it was our in-house engineering department, so it was not a consultant, but it was
All right.
reviewed by the county.
It was reviewed by you and the colleagues of yours that have the particular expertise needed to review it.
Correct.
And all of you as a group found that it met the applicable requirements of the Land Development Code and Comprehensive Plan, subject to the conditions of improvement.
Yes.
Then it went to the Technical Review Committee. And is that for purposes of assisting the judge on this, is that a committee where we come in a room like this and you have the planning director and the mosquito control district and the fire department and all the people that have some element that needs to be approved, and they review it?
Yes, but we kind of got it backwards there. So the initial review did not find it compliant. But after going through TRC and them conditionally approving it and them resubmitting it, at that point it was considered compliant and it moved forward to the design review board.
All right. So the TRC with conditions found it compliant. Then it was re-reviewed by you and the planning staff and found it complied.
Correct.
Then it went to the design review board, which is not all of it involving land development code.
Right.
And comprehensive plan, only part of it, but their
Right.
part of it, they found compliant.
Correct.
Then it went to the planning commission, again, with a forum much like this, where the recommendation you're making today to approve was the same before the planning commission, correct?
Yes, they recommended approving it.
And they, again, voted 5-0, which was all the members of the planning commission present, to approve, correct? Meaning
Yes.
they found that it complied with all the applicable elements of the comprehensive plan and land development code, correct? And you are AICPA, you're a certified land planner. Is it your opinion, based on your education and experience, that this application for this development meets all the applicable provisions of land development code and comprehensive plan, subject to the conditions set
Yes.
forth in the development order?
Yes, I do.
Thank you.
Mr. Brown, I just want to, going through, you said the CLOMAR and the LOMAR, those are in the final order,
Yes.
conditions M, N, and N.
Got them 13 and 14 in my staff report.
Okay.
Okay.
CLOMAR F will be required for permit issuance, and then the N is approved. LOMAR F will be required for certificate of completion.
Yes, correct.
Okay, all right, thank you.
And just to clarify, based on, when we say permit, we mean building permit.
Yes, the completion is where the development order inspector signs off on the project that everything's complete and it's compliant with the approved plans.
Okay, thank you.
So one is the building permit, the other is the DO inspector sign off.
Okay, Ms. Davis, do you have any follow-up?
I do not.
Okay,
Judge, I felt it was beneficial to use the acronyms. It's kind of like the military. You're lost until you get these people to define them. All right.
to have it in the record.
We would call Melissa Ward.
Ms. Davis, you have no one else, right?
I do not.
Okay, Ms. Ward, is that right? Okay. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Um,
Mr. Shipman, whenever you're ready. And can you give me your name again? Full name?
Melissa Ward, W-A-R-D.
Judge, we're going to, at the end of her, or at each witness's testimony, we put the exhibits in a notebook with a tab that actually includes their exhibit that they just put in, that
Okay.
I'd like to give you so that it'd be easier for you to follow along as people testify.
I'm going to give it back to you after the hearing.
That's fine.
That's fine.
Okay. And you've provided a copy for the, to the clerk.
All right, Ms. Ward, could you tell the judge your credentials, starting with, and work experience in the area of land planning?
Before we start down this path, I would have no objection to Ms. Ward testifying as an expert in planning. She has testified in that capacity previously.
Okay. Well, if the parties are stipulating, then I'll accept Ms. Ward as an expert in planning.
Now, the only thing I'd just like to get on the record, she's AICP certified. Are you?
I am an AICP certified planner with the American Planning Association with 20 years experience, 11 of which is for Walton County.
Thank you.
Ms. Ward, did you review the application for purposes of determining whether or not the application complies with all the relevant provisions of the Comprehensive Plan and Land Development Code for Walton County?
I did.
And did you prepare a report with your findings?
I did.
And is that exhibit number 3 in the notebook?
It is.
Okay. If you could, would you go over with the court the relevant provisions that would apply to from the Comprehensive Plan and the Land Development Code to this development, what they are and how the application complies, and we'll exclude those that require an engineer to determine.
Okay. So this property is located on Highway 98 between North Holiday Road and Botanic Way, and is approximately 10 acres. The survey gives the exact acreage on it, and that's attached to the report as Exhibit A. The site has a future land use designation of mixed use under policy L-1.6.1, and a zoning of coastal center mixed use, which falls under that same policy, but also in the Land Development Code with its defining guidelines under 2.02.21, which is reflected in the exhibits B and C, and then also in G. The proposal for the development is a 49-unit vehicle of multiple types: vehicle, cars, boats, recreational vehicle storage with an amenity center or sales center. And the code for coastal center mixed use as primary use or a use by right allows general commercial uses. And to further define general commercial uses, in section 2.03.00 under primary uses categories is listed mini storage or warehousing. So therefore, a mini storage or warehousing is a primary use allowed in coastal center mixed use. The coastal center mixed use has a maximum floor area ratio of 85%. However, if you are impacting wetlands, then for the area that's impacted, that is reduced down to 10%. So you calculate the area that's not impacting, and you calculate the area that's impacted. And for this property and for the impacts, it equals out to a 68% maximum area. And the maximum floor area ratio is 200% or 2.0. And that is not, and that, anyway, for 10 acres is quite large. I would like to talk very briefly about the special development standards under coastal center mixed use. There are a number of special development standards under that particular criteria, most of which do not apply to this development. So I have skipped over items, the issue of the maximum floor area, the maximum height, because it is significantly below that. There's no limited lodging and so forth, and it's not single family, so that's not a criteria. However, it does say that there will be no commercial outdoor amusement uses and that they are specifically prohibited in that zoning district, so that is a special condition that this project meets. They are not proposing any commercial outdoor amusement areas. When in talking about how this project complies, when it has to do in regard to the floor area ratio, again, it's 200% for the site. It's 10 acres. It's quite large. There's no way we could max that out. The floor area ratio for this total site is 17%. That's including all of the garages and the amenity center. So it's well within the range for coastal center mixed use. And for the impervious surface ratio, as I mentioned, any impacts to the wetlands reduces that area impacted down to 10%. So calculating the overall is allowable up to 68%. Our impervious surface is 33%, well within the allowable use on that property. I want to go over the parking requirements. That the parking is established under 50202 of the Land Development Code, and it establishes for warehouses 1 space per 10 storage units plus 2 spaces for staff. And so that's where the 12 units came from in determining that's what's required. However, what is provided more specifically, the sales center is 1,363 square feet. And the parking for that would be 1 space per 350 square feet, providing 4 parking spaces. And the 49 storage units allows for, using that 1 per 10, allows for 7.2. But what they've done is they've calculated the outside and the inside parking at a total of 228 parking spaces. So this is based on the fact that in the code, it specifically states that you can use the Institute of Transportation Engineers manual for parking, and that's what the engineer did. And he can discuss it further, but that's the method that they used to ensure they had adequate parking. And that section would be in section 50102, which is also an exhibit to the report. The setbacks for the property, every wetland on the site would have a 25-foot wetland buffer, and the commercial setbacks are 25 feet in the front, 10 on the sides, and 20 feet in the rear. Those provided for the development in the front is 96.2 feet. On the sides, minimum is 11.5 feet, and in the rear, the minimum is 27.5 feet. So we far exceed the required building setbacks and have adequate buffers along any wetland barriers. Another thing that is reviewed is the landscaping areas. We provide the 10% of the parking lot landscaping, and there is a landscape plan in the civil plans that were submitted, LP2, that shows of 880 square feet of parking surface and 88 square feet of landscape, meeting that 10% requirement. There is 288 parking spaces, most of which are in the building and do not require a landscape for those. There's 160 linear feet of frontage along the buildings that requires 80 planters which are provided per the landscape plan on LP2, which is a part of the civil set. So we meet those minimum requirements and exceed most of them. In the report, on page 6 of my report, there is a chart that talks about the landscaping that's provided, the number of trees and so forth, and how we meet those criteria. We exceed them, and we meet and or exceed them at a required 5 trees, required 3 understory, and 408 shrubs. We meet the requirements for that. The project does require landscaping along the exterior of the property, the perimeter, most of which is natural habitat. And then again, on page 7 of the report, there is an additional canopy trees where 4 is required. They have 6. And understory trees, 5 understory trees are required. They have 7. And the 10 shrubs are required along the northern property line. There are 14. And this continues around the perimeters of the property, also shown on the landscaping plan LP2, and it's an exhibit to the report, which is submitted for your review. The 10-acre parcel has 6.88 acres of wetlands, which include primary and secondary wetlands, as defined in the code. And the secondary wetlands are defined as the 25-foot buffers to those wetlands, as explained in 40103 of the Land Development Code, which is Exhibit L to the report. The application proposes an impact of 2.33 acres of wetlands. And as I mentioned earlier, that includes a reduction in the developable area from 85% down to 10%. They also have already applied for and obtained their environmental resource permits for this impact, and have mitigated for the same with Nakusi Plantation. That's Exhibit M of the report. It's important to note that every project in the county, and every project in general, has to meet concurrency requirements. And concurrency requirements are reflected in section 3.0100 of the code. And they include roads, potable water, wastewater, drainage facilities, solid waste, and recreational facilities. In Exhibit N of the report, it includes that section. The project, there would be discussion about the mobility fee and traffic. Mr. Shipman will probably review with the engineer. Potable water, we have a capacity letter from the South Walton Utility Companies, and the code specifically includes a presumption of available capacity with that availability letter from the utility company. That is the same for wastewater, which is Exhibit E of the report, with the South Walton Utility Company providing available capacity. The engineer will discuss the drainage facilities, but it is important to note in the civil plans that attach to the report as Exhibit I also reflect the approval memo from the staff of their compliance with the drainage requirements of the code. Solid waste is a concurrency. Walton County presumes a capacity for all development as they are in a contractual agreement with Waste Management Services. Therefore, they are compliant with that method of concurrency. And the recreational facilities, this project is non-residential and does not require any recreational lands to be dedicated to the public. So in conclusion, the proposed project is consistent with the comprehensive plan policy for mixed use. It is consistent. It complies with the Land Development Code, zoning for coastal center mixed use, Chapter 3 concurrency, resource protection of Chapter 4, and setbacks and development standards of Chapter 5. And therefore, it is my opinion professionally that the project meets the code and the comp plan and is ready for development approval.
All I have for this witness at this time.
Ms. Davis, do you have any questions for this witness?
I do not. Ms. Ward summarized everything I would have asked her.
Thank you.
All right, and so we are going to offer this into evidence?
Yes, ma'am.
Okay, we're going to call that applicant's Exhibit 3.
Yes, ma'am.
Just for the record, that consists of the report plus attachments A through R? No. Is that right? A through R.
All right, we would call Mr. Curtis Smith. Smith, would you, oh, you need sworn in.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do. Smith, would you state your name and your occupation?
My name is William Curtis Smith. I go by my middle name Curtis. I'm a licensed professional civil engineer in the state of Florida as well as Tennessee. All of my Tennessee license is in an active status as I practice primarily here now. Let me go to credentials.
I'm sorry, what kind of engineer did you say?
A licensed professional
Oh,
engineer.
professional. Okay.
And do you practice with a particular company?
Yes, so I'll just go over my credentials briefly. I have a Bachelor of Science in Civil and Environmental Engineering. My particular emphasis in the licensed engineer category is civil engineering, land development, traffic and transportation, and stormwater as well.
Your Honor, Mr. Smith has previously testified in expert capacity as a civil engineer within this forum, so we would have no objection.
Okay, and Mr. Shipman, you want to offer him as an
Yes,
expert
ma'am.
in engineering, civil engineering?
Yes, ma'am.
Mr. Smith will be considered an expert and is accepted as such. Go ahead.
Mr. Smith, did you perform the engineering work and prepare the application for this development?
Yes, sir, I did.
And is exhibit number 4 a letter where you conveyed the application to the planning department?
That is correct. It's the project narrative summarizing the project.
Did you obtain and use documents from somebody else as well to do your application?
Yes, we obtained an environmental report, environmental site assessment report that includes wetland-related information as well as any threatened and endangered species, special habitat, anything like that.
And the environmental report is exhibit number 5 by Ecological Resource Consultants, Inc.
That's correct.
And as a result, did you receive a environmental resource permit from the Northwest Florida Water Management District for this development?
That is correct. That permit covers the wetland impacts as well as the stormwater management.
And is that exhibit 6? Mr. Smith, as part of your employment in engineering, are you frequently called upon to develop applications for development orders in Walton County?
I am.
And does that require you to be familiar with the aspects of the Walton County Comprehensive Plan and Land Development Code?
It does.
And in your opinion, as a licensed professional engineer working in this area on developments, does the application for this development meet or exceed the requirements of the relevant applicable provisions of the Comprehensive Plan and Land Development Code?
Yes, sir.
I would like to go over some specific provisions of or activities that you did. First of all, did you do the site plan for this development?
Yes, sir, we did. The site layout plan that you're referring to, C200 site plan, we developed that plan.
And what tab is that?
Tab 10.
Tab 10. Did you also, did the site layout, when you performed it, did it meet all the requirements set forth in the Land Development Code and Comprehensive Plan for Walton County?
Yes.
Did you perform or design a stormwater system to comply with the requirements of the Walton County Comprehensive Plan and Land Development Code?
Yes, sir, we did. That information is drawings, the C300 series of drawings, as well as the stormwater management report.
And is that tab number 10 and 11?
That is tab number 11. And 13 is the stormwater management report. Tab number 11 is the full set of drawings.
Could you explain to the judge the relevant requirements of the stormwater plan and how it complies? Yes.
So this particular project had a substantial amount of floodplains on it. So as the design progressed, the emphasis was on ensuring that the floodplain regulations were met first. Walton County has specific requirements for water quality volume. This design far exceeded that, as it was actually required to meet more stringent requirements from the state, Northwest Florida Water Management District. So we've met those with 2 wet detention ponds, as well as some permeable pavers. We also split the phase 1 and phase 2 up. This project is a phased project, so they stand alone. Phase 1 has its own stormwater system. Phase 2 has its own, and both also meet the floodplain development regulations individually.
There was an issue brought up about parking. Could you explain the parking requirements and how they were determined?
Yes. So this particular project, we thought it would be best, because this is a unique project, not quite like a typical mini storage facility where people are bringing in stored goods and leaving. This is really for those vehicles themselves. We went to the Institute of Transportation Engineers parking generation and used that book that is allowed by the Walton County Land Development Code to check to see what those requirements are based on those. And then we also checked based on the Walton County Code. It was actually a little bit more stringent from the ITE, so we used that in the required parking. However, as you see, we have several hundred more than what is actually required for that type of use.
Then the Institute of
Transportation Engineers.
Is that a standard reference relied upon by civil engineers
It is.
practicing in this field?
ITE is relied upon for both parking and traffic generation.
And has that been, in your experience, generally accepted for those calculations?
Yes, it is, and it is specifically referenced in the Walton County Land Development Code.
Did you perform a traffic study?
We did.
Now, at one point, traffic studies were used to determine either mobility fees and before that, prop fair share fees. Are they used for anything today other than determination as to whether there's some sort of need for an improvement for access?
So yes, for turn lanes, intersection operations, for that purpose, as well as probably the most primary purpose today is for the Walton County Engineering Department to keep tabs on projected trips coming in the future.
Okay. But in this particular case, was there anything about the traffic study that would impact any aspect of the applicable land development code or comprehensive plan?
No, sir.
There was a question brought up, I believe, about some sort of future easement or cross easement
Yes, sir. So the access easement is already in place. It was in place for this property before my client purchased the property. It is referenced on the project survey that's in tab 8. That actually references the ingress egress easement coming up on the driveway. That is official records book 2200, page 376, I believe. And there is a cross access easement that goes east-west across this property and the adjoining property to the east. That is official records 2718, page 632. So those easements are all in place.
The tab number again.
It's on the survey, which is tab 8. And it says both ingress egress easement and the book and page. And then the east-west easement says cross ingress egress access easement. There's a book and page reference on that survey.
I got it.
And then, we didn't say it when we were going through it, but the traffic study is tab 12, which we also move into evidence along with the survey. And the stormwater plan is 13, which I think we moved into the evidence. As part of the development process, was there a requirement that it be reviewed by the engineering department at Walton County? And did you receive a letter from the engineering department, I believe it's tab 14, where they did their review and found it compliant with certain conditional approvals?
Yes, sir.
And one of those was that cross-access that we just referenced, correct?
Correct. They put typical conditions of approval.
Another one was proper stormwater, which we also just referenced, correct?
Correct.
Is there any item under the Land Development Code or Comprehensive Plan that does not meet or exceed the requirements?
No, sir, there's not.
Okay. That's all the questions I have, Your Honor.
Ms. Davis, do you have any questions for this witness?
No, I do not.
Mr. Shipman, do you have?
At this time, we would conclude the evidentiary presentation. I do not believe anyone has ever sought to intervene as a party in this case. They would have had to have done so by now. So I would want to reserve closing argument after public comment, but I think we're at the point, unless Ms. Davis disagrees with me, to open it up for public comment unless you have a rebuttal or something.
No, the county has no rebuttal on this project at this point, but I would say that I would agree at this, there's no one that's moved to request for party status. So, but we would still need to open it up at this point to see if anyone is making that assertion now, and then we can close the evidence portion and move into public comment.
Okay. If there's no other evidence from the parties, that will close the evidentiary portion. I would ask if there are any members of the public that want to speak on this item, that they come forward at this point. I don't see anyone moving. So I'm going to assume that there's no one who wants to speak today, and that there are no written comments that have been provided to the county for today's hearing. As such, I would allow the parties to make a short closing if they wish. I do have the proposed recommended order from the county, which I will rely on, and I would like to go over the exhibits at this point just to make sure I have everything entered. I have the staff report, which is the county exhibit 1. Then from the applicant, I have exhibit 3, 4, 8, 6, 3, 4, 6, 8, 10, 11, 12, and 13. And 14, I'm sorry. Okay. I have 8 as the egress map that we looked at. I don't remember looking at 8. Oh, we did look at, let's see. I'm sorry. 8 was the egress easement. That's a survey, okay. I have 11. Okay, I need to make sure that, if you want to step up to the mic, just to make sure that it's in the record, Mr. Shipman. Again, I have 3, 4, 6, 8, 10, 11, 12, 13, 14.
Yeah, we didn't. I believe those are what we've admitted, Your Honor.
All right,
Okay?
all right. Ms. Davis, Mr. Shipman, anything else that we need to get on the record before we conclude the hearing today?
Not from the county, Your Honor.
I'd just like to have about a 2-minute closing.
Okay,
The standard is whether or not we meet the comprehensive plan and land development code. I believe the evidence presented by both the county and the applicant is that we meet the comprehensive plan and land development code, and that there was no evidence presented that we did not. With that, we would ask that the court enter the order submitted by the county.
all right. That will conclude that hearing. Next up will be the Holiday Inn Express. But why don't we take a 5-minute break to let Mr. Shipman's group break down, and then we'll proceed.
You're welcome to keep that book, or do you want me?
Let me make sure that I can access it.
Usually
online.
leave it with the ALJ, just,
It will not be in line, so I guess I will keep it.
okay, yes.
Normally the clerk does upload it. She
Does
adds
upload.
it to, yeah. So Ms. Knopfger is filling in today, so she may not, but typically whatever gets moved in gets uploaded into InterGov after today.
Can we agree if I take this that I don't have to return it to you? I can
Yes,
just shred
yes,
it?
ma'am. We provide it
It's a
because,
courtesy copy.
because it's easier to look when we're talking
I
about it.
appreciate that, yeah.
And if you're like me, I write on things, so.
All right.
It's gonna take a while. All these people are here for
No, we got it.
it's gonna take a lot longer than this one.
Can I go to the bathroom that way, or do I have to go out?
It's in that hallway.
Okay. Bye, have a good day.
recommending body, they're recommending approval.
Otherwise it would have gone to the PS, quasi judicial, so that's why you.
Yeah, the county commission decided.
Hey, I'm Brooke.
I mean, he's still.
Right.
He's gotta go through it.
Uploaded all your stuff. All in there.
I don't think I know how to get.
So the way that we've set it up for the quasi, that way it was a little bit smoother, especially our public to be involved. The magistrates like dump them into sitting in. You know, we don't do the ALJ side at all. You know, at DOA's website, it doesn't get created through their system whatsoever. So. Yeah, that way, you know, because we talked about like maybe hiring one full-time, but I felt like this is a better, yeah, I felt like, exactly. Well, and you don't have the same, you know, it's not somebody that is contracted through the county that, you know, they're, well, they're still biased because their paycheck is dependent on the county. And our judges that are coming, I mean, they know their stuff, so I love this, yeah,
Some of
I
the
love
best judges in the state.
absolutely. So, yeah, somebody asked me the other day, oh no, I do not have the credentials for what they do. They know their stuff, so that is another level. And
Well, actually before the.
I just need, yeah, if we stipulate that time, if he's gonna call Margaret up there.
well, and but I mean, we can stipulate beforehand so that way you have the opportunity to cross-examine whoever you want to cross.
Because we would technically be in till.
You can wait.
Never worry about the one behind you.
Yeah.
I mean,
Yeah, actually. could say try.
All the demonstratives, I still want to make sure that PowerPoint and stuff, you know. These aren't our staff report and our, I don't think that it needs to be part of our staff.
Ms. Davis, whenever you're ready for the next one.
Sorry, Judge, this is just the first time that the three of us attorneys have all been in one room together.
Do you
so-
need more time?
No,
I'm not in any rush.
I think this was the last point that, excuse me, this was the last point that we had to discuss, and so I think we're all clear now. So-
Okay, if you need more time, just let me know, but I'm ready whenever you are. Okay, are we still recording? Okay. All right, for our next hearing is for DOA case 26-0366, which is the Holiday Inn Express, which is project number MAJ 25-000053. And before we get started, if we could just get appearances again, either the council or representatives for the applicant.
Your Honor, Brooke Davis on behalf of the county. It's my understanding there's not an attorney representing the applicant at this point. Their engineer is present, though, Mr. Curtis Smith.
Mr. Smith, can I just get your address for the record? Okay, and can I just get you to come up to the mic so we can get you on the record and give your full name and the address of where the notice and the information should go?
My name is Kalpesh Patel, and I'm from the Sunrise 850 LLC group, and our address is 2709 Longleaf Road, Panama City, Florida 32405. And I'm here with the ownership group, and we have our planner and engineer, Curtis Smith, representing us.
Okay, and Kalpesh, K-A-L?
Kalpesh. Last name Patel, Patel.
I got that. Okay,
Thank you.
all right. And Mr. Smith, are you going to present or will the owner present?
Yes, ma'am, I'll present. our
Okay,
side.
Ms. Brooke is going to go first, but just so we're clear on the record. Ms. Brooke?
Yeah, Judge, just to be clear, typically the way that's done, if there hasn't been an attorney that's going to represent the other side, typically the way we've been doing it is I'll call our project manager for the county's perspective, and then I'll call their engineer or planner to come and provide some testimony. So,
Okay, thank you.
Your Honor, at this point, I would call Miss Ayanna Reed.
Ms. Reed, if you'll come up. I'm going to swear you in. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
And give me your name. Just spell out your name for me.
Ayanna Reed, that's Ayanna. Last name Reed.
Thank you.
And Miss Reed, where do you currently work?
I work for the Walton County Planning and Development Services Department.
And how long have you worked there?
I've worked here for almost 2 years.
And what's your current job title?
Senior planner.
Have you previously testified as an expert in quasi-judicial hearings as a planner?
Yes.
Your Honor, I'd ask at this time that she be moved in as an expert in planning.
Right. Ms. Reed, I've accepted you as expert in planning.
Ms. Reed, can you give us a bit of an overview of exactly what the request is today on this project?
Sure. So the Holiday Inn Express is a major development order application. The applicant is requesting to develop a hotel with 104 rooms on 2.57 plus or minus acres. The project has a future land use of mixed use and a zoning of village mixed use. It's in District 5 on the north side of Highway 98 West, approximately 0.195 miles east of Don Bishop Road and 0.249 miles west of intersection Highway 98 West crossover in Musset Bayou.
And when was the application received for this project?
The application was received on September 16th of 2025.
I know for Planning Commission, you prepared a bit of a narrative to talk about this project. Can you provide to the judge that narrative at this point?
Yeah, sure. So I can go over briefly the infrastructure summary and the project analysis that was presented at the Planning Commission and as a part of the staff report for today's hearing, just to kind of provide additional context on the project and what staff reviewed. So water and sewer is going to be provided by regional utilities for the site. The proposed development has 104 rooms, as I mentioned earlier, and it's estimated to generate 52 p.m. peak hours, hour trips, 27 entering and 25 exiting. The applicant determined this using the ITE trip generation and ITE codes for a hotel use. A turn lane warrant was performed for a westbound right turn lane into the facility. The applicant did have a pre-application meeting with FDOT, and they did receive the green light from FDOT to pursue that for the site.
FDOT is Florida Department of Transportation.
Florida Department of Transportation. And let's see. So the engineering analysis that was performed for stormwater by Nautilus Engineering, which is the applicant, was designed to accommodate a 25-year and 100-year critical events. In terms of site access, the applicant does comply with several access points that folks can use to enter the site. One is via Highway 98 for the westbound right turn lane. One is via the cross-access easement to interconnect to the parcel to the west. And there is one future access via a stub out to interconnect the parcel to the east. In terms of our project analysis, as I mentioned earlier, regarding the future land use and zoning district, this is mixed use and village mixed use. The project is compliant with the objectives and policies outlined in the comprehensive plan and land development code. In terms of density, that was not applicable for this commercial development because this is a commercial development, not a residential development. The applicant did show us on their site plan, which is a part of the exhibits in the staff report, that they do come in under what our maximum allowed impervious surface area or ratio is. They've also come in at under the maximum allowed for the floor area ratio. Their structure height we find is compliant, and they're proposing enough parking to accommodate the use on the site, which also includes ADA spaces. I will note that this is in flood zone X. There's very minimal impacts to the wetland area, and that the allowed ISR and FAR from the county's land development code are specifically for projects that front US Highway 98 per LDC section 2.02.23.f.1.b. But besides that, we didn't see any other issues with the project, and we did find the application to be complete and substantially consistent with the LDC, or the Land Development Code, and the Comprehensive Plan.
You mentioned that the stormwater management system complies with a 25-year, 100-year standard. Is that sufficient under Land Development Code standards for this project?
Yes.
What about the setbacks? Are they compliant with LDC standards for setbacks?
For commercial use and commercial building, yes.
Are there any environmental concerns to the project?
No.
And what about preservation? Are there any preservation requirements?
No. Per the environmental review from our environmental planner, no, there are no concerns.
Does this project require a sidewalk to be built?
Yes, it does.
That's one of the conditions for the project to move forward?
Yes, it is.
Now, this project, as with all other projects, it went through the technical review committee, is that correct?
Correct.
And planning commission?
Correct.
Did it go through DRB as well?
Yes, it did.
And did DRB and technical review committee, did they have comments and direction for this project?
They did. They had several comments regarding the aesthetic design per our requirements in Chapter 6 of the Land Development Code regarding the architectural feature requirements that we have for building design, and also the recommended color palette for the building design. We did have those conversations. The applicant did bring their proposal up to compliance with Chapter 6 requirements, and they were able to move forward under the DRB's conditional approval that they meet those requirements.
And so any comments from Design Review Board and Technical Review Committee, have those either been satisfied or turned into conditions of approval in the proposed final order?
Yes, they have. And I would also like to add to the record that we did not receive any public comment on this project.
Are there any other special considerations about this project that we need to think about today?
Nothing besides the fact that it is compliant with the Land Development Code and the Comprehensive Plan.
And did you prepare a staff report for this project?
Yes.
Your Honor, at this time, I would ask to move into evidence as County Exhibit 1, the staff report with the inserts.
County Exhibit 1 with the inserts are admitted.
And we discussed a second ago the proposed final order. Have you prepared one for this project?
Yes, I did.
And did you include any conditions for approval for the project?
Yes.
And have there been any objections to those conditions voiced by the applicant?
Not that I am aware of.
Are all of those conditions items that you gleaned from compiling that staff report that we talked about?
Yes, they are.
I don't have any other questions for Ms. Reed, Your Honor.
I have just a couple. Can you go through the process again? You went through the TRC. Can you give me the date on that? It's usually in the agenda item, but I don't see it.
So the TRC meeting was held on November 5th of 2025.
Okay, and then where did it go?
So from there, the next step would be to the Design Review Board, and that was held on November 6th of 2025. And then the next step after that is Planning Commission, and that was held on December 11th of 2025.
Thank you. That's the only question I have.
Your Honor, the next I would call would be Mr. Curtis Smith.
Mr. Smith, I believe you've already been sworn in, so I'm not going to swear you in again, but you are still under oath.
Did we swear Ms. Reed?
Yes, I did.
Okay. Sorry. Okay. All right. Mr. Smith, are you the applicant on this project?
Yes, ma'am. I am the representative of the applicant.
Okay. And you are the engineer for the project, is that correct?
That's correct.
And you have previously testified, in fact, earlier today, as an expert in civil engineering, is that correct? Gotta say a little louder.
Yes, ma'am. Civil engineering, traffic, and stormwater engineering.
Your Honor, at this time, I would ask for Mr. Smith to have the opportunity to testify in a narrative fashion
Okay, on what?
on his engineering for the project.
Okay, all right.
So I believe Ms. Reed covered most everything pretty well. The Exhibit 2 from the Planning Department has our project narrative in it that describes thoroughly what the project is, the 104-unit hotel room on 2.57 acres. I'll note it says on here that there are jurisdictional wetlands. Some of those wetlands were impacted as part of the development. As such, we do have some punitive damages on impervious surface ratio, which were taken to an effect in calculating the impervious surface ratio allowable on this project. It meets all of those requirements. As part of those central wetlands, we did design a culvert that discharges from the FDOT, Florida Department of Transportation, right-of-way of Highway 98 that passes below the parking lot of this project. We have proposed a drainage easement, which will be finalized as part of that FDOT permit. We do still have to finalize that permit with FDOT. Those permits are typically a condition of starting construction. So since the county cannot stop development orders for state permits to be complete, we always ensure that those are complete before construction can start on these projects. So that also goes for the turn lane itself. The DOT will do a final review and approval of the westbound right turn lane into the project site. And as Ayana stated earlier, we have had a pre-application meeting with DOT and have gone over this. We just have to finalize that particular permit. Cross connection to both sides has been provided. Those easements have been drafted. Now that the project is moving forward, we will finalize and record those easements. That is stated as a condition of the development order at the end. And those conditions are, I don't see an exhibit number, but that's at the end of the planning packet.
Okay, I have the proposed order. It says provide a copy of FDOT approval and all permit documents associated with improvements proposed along US Highway 98. Is that the condition that addresses?
That is a condition prior to starting construction of the project. That's how that typically is handled.
It also says a cross-connection easement must be fully executed before the issuance of the final development order.
And we will provide those to them before the development order is issued and signed. We'll provide the recorded copies of those easements.
To Walton County.
Yes.
Yes, okay, go ahead.
So as Ayanna stated also, we meet all of the stormwater management requirements. This project was required to meet a 25-year critical storm attenuation. This project actually meets a 100-year critical storm attenuation, so it far exceeds the minimum requirements. And much of that has to do with the new state stormwater management requirements that require much more stringent regulations than local requirements do at this time. The state permit for wetlands and stormwater management has been obtained. That's stated also in the conditions of approval to obtain those prior to starting construction. We have provided those to the county through their permit portal system. We've uploaded those. That is really all I have on the narrative. I don't know that I need to belabor describing the project design or anything. It was a fairly standard commercial development project where all the parking requirements and dimensional requirements of parking lots and things were considered. As Ayanna stated, everything meets the code requirements in that aspect.
Okay, and the wetlands permits, who are they issued by?
The wetland permit is issued from the Northwest Florida Water Management District. It's an environmental resource permit, and for the record, I'll state the permit number is IND-131-327900-1. I do have a copy of it, but I only have one, so I probably can't present it here, but it is actually uploaded onto the permit portal for the county.
All right, that's fine. Ms. Davis, do you have any questions for Mr. Smith? I'm sorry.
I do not.
Okay. Ms. Davis, do you have any other witnesses?
Not at this time, Your Honor.
All right, that will conclude the evidentiary portion of the hearing. Is there anyone here to speak on the project from the public? Hearing no one, that will conclude the hearing on the Holiday Inn Express.
Judge,
Oh, sorry.
If we can have about 3 minutes before we conclude the hearing.
Okay, yeah, we'll take a 3-minute break, and then we will resume the Holiday Inn hearing. We'll wait for the clerk to come back.
Yes, Your Honor. Your Honor, my understanding is we're back on the record at this point. The county would be requesting a continuance on this project.
For the Holiday Inn Express Hotel?
Yes, Your Honor.
Okay, and how long do you need?
The problem is, I know next month would not be Your Honor that would be present. And at this point, you've heard the majority of the testimony and evidence. So I think we have to continue it 2 months.
Okay.
For Your Honor to return.
All right, we will determine the date based of,
Believe or no?
of April? Of May.
May 28th, is that correct?
Okay, I am not sure, we're not doing a straight. I'm gonna grant a 2-month continuance, and if we need to continue it further, we can do it additionally through notice.
Yes, Your Honor.
Okay. All right. Anything else that we need to put on the record?
Not at this time, Your Honor.
Okay. All right, so we'll continue that. And are you ready to proceed with the next hearing on the preserves? Okay. If I can have, we'll take 5 minutes so we can have everybody get prepared that needs to come up and take off.
Hours, minutes.
Can you hear me? Okay.
Yes,
Yeah, all right.
I did have the representative for the applicants for the Holiday Inn Express here, so that way we could do a 30-day instead of the 60-day that we had previously discussed.
Okay.
So,
We're agreeable to this.
The 30-day, okay.
So the date was the 20th.
April 23rd.
April 23rd.
Does it have to be renoticed and things since it's date certain?
It should be preserved since the date certain has been announced.
Okay, and if we need to move it again, we'll do that. All right. We're now going to move on to the next agenda item, which is Walton County 26-0367, the preserves at Santa Rosa Beach, which is project number MAJ 25-000057. And if I can get appearances again, and we'll start with the county.
Your Honor, Brooke Davis on behalf of Walton County.
For the applicant?
Stephen Tatum, address is 4475 Legendary Drive.
And Tatum is Tatum?
Correct. And the city is Destin, Florida, 32541.
Your Honor, Terrell Arline, A-R-L-I-N-E, for the South Walton Community Council who have sought party status. My address is 1819 Tammy Amy Drive, Tallahassee, 32301.
And Your Honor, the county as well as the applicant, it's my understanding as well, stipulates to the party status for Mr. Arline's participant, the South Walton Community Council, on this project.
Your Honor, could I hand out a copy of our motion?
Yes, has it been filed with the clerk?
Send it to planning staff.
I'd be happy to accept. I don't have, I can't get onto the portal from here for some reason. All right, thank you.
For the record, I wanted to make sure that the motion for party status was granted and to recognize that the county and the applicant have stipulated to the standing of the South Walton Community Council, which we may call SWCC in this hearing.
Okay, and Mr. Tatum, are you in agreement with that?
Yes, Your Honor.
All right, so as far as the party status, it's been granted for SWCC. And Mr. Arline, I think what we'll do is we'll let the county go first, then we'll have the applicant present, and then I will allow you to present, and we'll end with the county.
Fine, Your Honor.
All right, thank you. And we'll take public comment, and then I'll let all of the applicant and the county respond to public comment if necessary. Okay?
Mr. Arline, in our understanding of the ordinance, he will be allowed to cross-examine any witnesses throughout the process.
Yes, as a party, you have full party status. I don't know where you want to sit, as far,
I'm fine there.
okay.
And I have an opening statement, a little PowerPoint presentation, but I'll just do that when we are called up to make our presentation.
Okay, that's probably best. You can make it in your case. All right, Miss Davis.
Yes, Your Honor, I would call the project manager, Mr. Tim Brown.
Okay, Mr. Brown, you were previously sworn in and you were still under oath.
Yes, Your Honor.
Mr. Brown, can you state your name for the record?
Timothy Brown,
And where do you work?
Walton County Planning and Development,
And how long have you worked there?
almost 18 years,
And what's your current job title?
senior planner.
And are you AICP certified?
I am.
And meaning the, gosh, I don't even know.
American Institute of Certified Planners.
There we go. All right. Mr. Brown, you're the project manager on this case, is that correct?
Yes.
Can you give us a little bit of an overview of what we're talking about here today?
Sure. This is a major development order application requesting approval to develop 39 single-family residential lots and associated infrastructure on 20.06 acres with the future land use of conservation residential and a zoning of conservation residential 2-to-1.
And I know you've previously provided a bit more of a narrative to the Planning Commission. If you want to kind of walk us through the project and where we've started and where we're going with this.
Sure. So this went before the Technical Review Committee on January 7th. They approved it by a vote of 4-0 to move it forward to the Planning Commission. It went to the Planning Commission on February 12th, 2026. They recommended denial of the project by a vote of 4-1. Go over some of the parameters.
When did the application come in on this project?
November 6th, 2025.
Sorry, go ahead, Mr. Brown.
So conservation residential zoning is treated a little bit differently. It has a open space requirement of 60%. So the director did a director's determination to highlight what would count as open space in this zoning district. The county also has a definition of open space, but the director's determination goes directly to the conservation residential zoning. So I'll just go over a little bit of the project. The density in conservation 2-to-1 is allowed is 2 units per acre. This project's at 1.94 units per acre. They're proposing, well, the required parking is 1 space per 900 square feet of heated and cooling living area for single-family residential. They're proposing 117 parking spaces.
So what does that mean? Since we're talking about 1 space per 900 square foot, is it at this point we're saying that the size of the houses still need to be determined, and how does that work since we have a definite number of parking spaces that are proposed?
Well, they were proposing 3 per parcel, so that's how we get to 117. The requirement is based on the size of the home, so unless we know exactly what that is ahead of time, there's no way to calculate what that requirement would be right this minute. But they're proposing that it'll be large enough that each unit will have 3 parking spaces.
So is it necessary at this point to determine the size of the homes in order for the development order to be granted on this level?
No, that happens at the building permit stage.
Go ahead.
So there's 1.48 acres of wetlands, 0.38 acres are being impacted, which again has a penalty of 10% impervious surface ratio. It's in an AE7 and an AE8 flood zone, so the entire project is in the flood plain, so they'll have to meet FEMA requirements in addition to the county and the state requirements. They're going to generate 40 new trips on the road. Again, there's no fee or anything involved with traffic, only operational improvements, and according to Public Works, there's no need for any operational improvements with 40 new trips on the road.
Let's back up to the wetland area that you talked about. You said that there's 1.48 acres on site and 0.38 acres are going to be impacted. Was that correct?
Yes.
Is that allowed under the Land Development Code and Comprehensive Plan?
That's a state issue or a federal issue. We have no input with that. If they get an environmental resource permit through the state or through the Army Corps of Engineers. But again, we penalize them for doing that. And I'm sorry, I got that backwards. This is a residential project, so the 0.38 acres would be a density penalty of 1 unit per 20 acres. So if you go to the state or the feds and get an environmental resource permit, which allows you to fill your wetlands, our side of it is we're going to penalize you for filling those wetlands.
So at this point, this project, and in your opinion as a planner, this project would meet the density even with that penalization?
Yes, it's at the maximum. 39 units is the most that can be provided under the density for this zoning district.
Go ahead, Mr. Brown.
Well, unless you want me to be a little more specific, I think I've covered all the highlights.
Yeah, let's walk through. What about, is there going to be water and sewer to this site?
Yes, this is in the regional utilities service area. They have available water and sewer capacity.
I want to make sure, just housekeeping purposes, Mr. Brown has previously testified today in the capacity as an expert in planning. I want to make sure that he is granted that status in this hearing as well.
No objections from us, Your Honor.
No objection.
Okay. Mr. Brown, you are accepted again as an expert in planning.
So you were saying that there is water and sewer to this site? Is that
Yes,
correct?
there is availability.
Okay. And is there a sidewalk required on the site?
Yes, with a residential project, you're required to put a sidewalk on both sides of the residential street. They have done that.
And can you explain when it's anticipated that be built?
Typically, they will give us a letter of credit or a bond, not a bond, but a surety for the sidewalk. Typically, they put it in last because if they put it in ahead of time, as they're building the homes, it tends to get damaged. So typically, it goes in last.
Is the development located in a flood zone?
Yes, it is in the 100-year floodplain.
And does the applicant need to do anything to be compliant with the Land Development Code and Comprehensive Plan since they're in that flood zone?
Yes, we do have floodplain management regulations in Chapter 4 of our code, but like I mentioned earlier, in addition to that, they still have to follow FEMA requirements as well.
Had you had the opportunity to look at the setbacks for the site?
Yes, they're using our standard residential setbacks, 20 in the front, 15 in the rear, 7.5 on the sides.
So in your opinion, this site is compliant with the Land Development Code setbacks?
Yes, it is.
Let's look at environmental concerns for a minute.
Well, the main environmental concern would be the open space. Conservation residential 2-to-1 requires a minimum of 60% open space. You know, they've got their environmental resource permit. They're allowed to fill the wetlands. But we need to verify that they're meeting that 60% requirement, and that's where the director's determination comes into play because it specifically identifies what can be counted as open space, and they are compliant. They're a little over 60% open space.
Okay, so you're saying that the site requires 60% open space, and they minimally exceed that 60%.
Correct.
Are there any other special considerations about the site that we need to talk about today?
I don't think so. I mean, we have requirements of putting the wetland buffer and the landscape buffer into common area. They've done that. I mean, once it's platted, it will show on the plat as common area as well. But I think that's it. They're doing the wetland buffer. They're doing the landscape buffer. They have, like we mentioned, minimally met the open space requirements. So I don't think there's any outstanding issues here at all.
Can you explain why we're talking about two separate buffers, the wetland buffer and the landscape buffer?
So Chapter 4 of our code requires that if you have a wetland, you have to have it's called a secondary buffer. It's required to provide a 25-foot buffer between the development and the wetland. When the wetland is filled, that area where it's filled, the wetland buffer does go away. The landscape buffer, which is in Chapter 5 of our code, provides screening between developments that either are, commercial next to residential or residential next to residential that has a higher density. So the higher density has to screen against a lower density project, and that's, in this case, we have both. They have a wetland that's not being impacted, so they have a 25-foot wetland buffer around that wetland, and then they have the landscape buffer to screen them from the developments adjacent to them and the road.
So is this project, are you saying that this project is of a higher density than adjoining properties?
Yes. Actually, most of the area is vacant at the moment, but we still require a landscape buffer, thinking that when it does come in, it'll be at a different density. This is a 20-acre project, so it's a fairly large development, but currently most of that area is vacant.
So it's not that the other properties are currently developed and of a different density. It's more of a landscape buffer for thinking into the future.
Correct.
Okay. I noticed that you notated in your staff report that there was some previous action. Can you explain what that is and why it's important here?
Yes, so the northern 10 acres received a development order last year for 19 lots. So that's an active development order. They were going to come back and mirror this property with the parcel to the south, so there would be two separate development orders for each parcel. They decided they would combine the parcel and do one development. So this will supersede, if this one is approved, it'll supersede the previous development order. So it'll be a 20-acre project with 39 lots. But currently that northern lot does have a DO for 19 lots.
So you're saying that this project is actually more than one parcel put together?
Two parcels, yes, 10 acre, more or less 10, it's 20.06, but more or less they're 10 acres each.
Did you prepare a staff report for this project?
I did.
And have you received public comments on the project?
Yes, we did not receive anything in the last couple of weeks, but we did receive public comment. It's uploaded into Intergov as ALJ public comment.
Your Honor, I would ask to have the staff report with the inserts moved in to evidence as County's Exhibit 1, and then the public comments as County's Exhibit 2, since it is referenced as a separate document in Intergov.
Okay. And do we have a copy of the comments?
Yes.
Is there any objection to entering those two exhibits?
Right there.
None from the applicant, Your Honor.
No objection from FWC.
All right. Let me just look at them and,
May I approach?
of course. That's fine. Okay. And are there just, is this just one? Or they're all combined? Right.
Yeah, they're front and back.
All right, I have, so C1, which will be the staff report, and the attachments will be admitted as into evidence, and C2, which are the public comments that are already uploaded, is that right?
Yes.
Yes, that will be considered C2. And they are also accepted into evidence.
Your Honor, I have no other questions for Mr. Brown at this point. Stand still.
All right. Is there any cross of Mr. Brown by Mr. Tatum or Mr. Arline? And I'll let Mr. Tatum go first.
Just one question, Mr. Brown. You stated that the rear setbacks were the typical setbacks on this project. Do you recall that we have a 5-foot rear setback because of the 20-foot landscape buffer in the rear?
I did forget about that. Where a lot butts up to the wetland buffer, Dakota allows that lot to go down to 5 feet where it abuts the buffer.
Just wanted to get that in the record. Thank you.
Okay, can you just explain that to me one more time?
Yes, where a lot abuts the 25-foot, what we call the secondary buffer,
Okay.
the setback is allowed to go from, if it's the rear, 15 feet, or if it's the side, 7.5, down to 5, because there's already 25 feet from that lot to the actual wetland.
So it would be +5.
Plus 5, yes.
Actually, we do need to clarify something there because you said wetland buffer. I didn't pick up on that the first time you said it. But is it not any buffer that is required by code that you set, you can do the 5-foot setback?
No.
That would be in 5.00033.
I don't think it applies to the landscape buffer.
This says, where the landscape buffer or scenic corridor requirements required by subsections 50102 and chapter 6 of this code, the Land Development Code, exceed the required setbacks established above, those requirements shall control.
Preservation.
New residential lots abutting dedicated preservation areas such as wetlands or natural communities averaging at least 10 feet in depth along the lot line may reduce side or rear yard building setbacks to 5 feet when abutting natural community preservation set-aside areas, provided the preservation or wetland area is not included within the lot. And so that is...
Can you give me that citation again? Is that from the LDC, from the Land Development Code?
Yes, Your Honor. It's 50003.
5003.
A sub 3.
So there's no actual preservation required under this, for this development under our code. However, the director's determination does require that the open space areas are shown as preservation on the lots, or I'm sorry, on the plat. So it's two different things. There's preservation that's required under the type of vegetation it is, so there's no requirement here. But in CR zoning, conservation residential zoning, you are required on your plat to show the open space, the 60% or more open space as preservation. So, and they've done that.
Let me just follow up one more time. Just for clarity, this is and this is in the staff report, but this is the site plan, and this is the preservation area that we're referring to. So it showed as preserved area on the plat with a 5-foot setback adjacent to it.
Yes.
Is that correct?
Yes.
All right, thank you. I'm sorry, that's it, Your Honor.
All right, Mr. Arline?
Your Honor, I am going to cross him on a couple of exhibits that are in our exhibit packet. Can I pass those out to you and counsel for the other side, and so we can talk about them?
Yes. Do you have a copy for the clerk?
I have a copy for the county.
Okay,
May I approach you?
of course. Okay, and it says exhibits, but the first thing is the PowerPoint, is that right? Which I'll consider as a demonstrative.
Yes, exhibit 1 would be a demonstrative. I'm not moving that in yet. I'm going to ask him about exhibit 5, which is a composite exhibit.
Okay.
That are the director interpretations he was talking about. And that's going to be the extent of my cross, but I wanted to at least have you to be able to see the exhibits that we're talking about.
Okay.
Okay, so you testified that there was a director's interpretation that was the basis of the decision that Planning Commission and the county made to authorize stormwater ponds in open space. Is that correct?
Correct, yes.
And what was the date of that director's interpretation?
Director's determination, April 25th, 2024. It does say but it's a director's. Oh, yeah. So, which was amended with a director's determination on February 10th, 2025.
Okay.
So there was an original and then it got amended.
So look at Exhibit 5, and it's got two director's interpretations.
Yes.
One is dated April 25th, 2024, and one is dated February 10th, 2025, correct? Now, isn't it true that that the planning department approved this project under the second director's interpretation, based upon the fact that on the last page of that interpretation, under conclusion, at paragraph 1, it states that open space could include, and I'm moving on, wet detention ponds. Is that right?
Correct.
Now, the prior director determination that was issued the year before that, you are familiar with this, correct?
Yes.
And this director's interpretation from April of 2024, the concluding paragraph on page 2 does not authorize wet detention ponds in open space, does it?
Not specifically, but it talks about environmentally sensitive areas, floodplains. Sometimes that can include stormwater as well, but no, it doesn't by name list retention ponds or stormwater.
Okay, now let's go back to the 2025 director's interpretation. And on page 2, in the staff analysis, there's a discussion about amendments to the state stormwater regulations. Is that right?
Yes, the state came down with some more restrictive regulations than the county standards.
So the second interpretation was based upon these new stormwater regulations from the state, right?
It appears so, yes.
And it says, this page speaks to entitlements of development that are affected by the stormwater regulations. Is that right?
I think it's specifically conservation residential, so it doesn't apply to any other zoning districts.
Yeah, I misspoke. Limited to the conservation residential zoning categories. This staff memo, this director's interpretation was intended to ensure entitlements of developers in the conservation residential, correct?
Yes, correct.
Now, is there anything in your LDRs that authorizes you to consider the entitlements of development as part of your review and determination of development orders?
Yes, absolutely.
Okay. I have no more questions. Oh, wait, I think I have one more. I'm sorry, I missed this. You testified earlier that most of the area is vacant.
Mm-hmm.
Would you agree that the lot directly to the south of this parcel is developed with a single family home? If you don't know, that's fine. But
Let me just look at the area.
I'm going to object. There's no relevance to that question.
Mr. Erline,
I'm just impeaching his statement that most of the area is vacant.
I'm going to allow it. I think the question is whether it's developed as single family, or does it matter what it's zoned?
Well, the presumption was that it was vacant to the south of it, and the evidence is that it's not. Would you agree that there's a house?
There does appear to be a house on this lot to the south, and that's actually why there's a required landscape buffer. It's to screen that single-family home to the south.
Are you generally familiar with this area that we call locally Chat Holly in Walton County?
Somewhat. I live north of the bay, so I don't get down to the south of the bay all that often, but yeah, I'm somewhat familiar with it.
Would you agree with me that the areas around this proposed development of 39 units contain no development that has 39 units on it? This is the first one?
It appears to be the first one, yes.
No more questions. Thank you.
Ms. Davis, do you have any follow-up?
Mr. Brown, on this project, what kind of compatibility review was required?
There's really not a compatibility review required under conservation residential.
Why is that?
Honestly, I'm not sure, but what we concentrate on is the open space because it's a low density and typically it's environmentally sensitive. So that's what we look at.
But is it as simple as the Land Development Code doesn't require a compatibility analysis for this?
It does not.
I don't have anything else.
Okay. Ms. Davis, do you have any other witnesses?
Yes, Your Honor. I'd call Director Schoen.
Okay. I don't believe that I'm sworn in. Do you swear or affirm that the testimony you're about to provide is the truth, but the truth?
I do.
All right.
Schoen, can you state your name for the record, please?
It's Stephen Schoen.
And where do you work?
I work for Walton County in the Planning Department,
And what's your current job title?
Director of Planning.
And how long have you held that job title?
That's a good question.
3 months?
No, interim. I was interim. I'd say total about a year now, I guess. Hard to keep track. But.
It's a blur. What was your job title prior to becoming Director of the Planning Services?
Deputy Director.
And how long did you hold that job title?
About a year, I suppose.
How long in total have you worked for Walton County Planning?
Since December of 19. So what's that going on? About 7 years this year. Will be 7 years in December.
I can't do math. I'm asking
Can't
around.
either. Yeah, that's why I'm a planner.
Mr. Schoen, are you AICP certified?
Yes.
And how long have you held that?
Just about 7 years. Maybe going on 8.
Have you previously testified as an expert in planning within quasi-judicial hearings?
I have.
And I would ask that he be qualified as an expert in planning.
Are there any objections? No. All right. Mr. Schoen, you've been accepted as an expert in planning.
Mr. Schoen, there was some previous discussion about some director's determinations regarding open space.
Mm-hmm.
Did you hear that?
Yeah, if it happened once I was in this room, then I heard it. Yeah.
Did you have some participation in those determinations?
I did.
Okay, can you explain to us exactly what your role was?
The previous director asked me to author both of those determinations.
And walk us through your thought process on the first determination that you created.
You mean outside of being asked to author the determination?
Right.
My thought process in drafting that was specifically looking at the language, the intent language in the in the comprehensive plan for conservation residential land use, and the zoning district language for conservation residential zoning districts.
And in your independent analysis, is that how you made that initial finding that the previous director signed off on?
That's right. Yep.
And then what changed that there was then a second determination?
It's my understanding after the first determination was issued that my director was approached by members of the public, specifically engineers and developers, that relayed to him concerns about being able to achieve any sort of development rights on the properties that are zoned conservation residential. With the new determination, after the state had adopted some changes to their stormwater requirements, moving away from quantity more to quality. Essentially, the argument, I believe, was made that those two standards together would relieve most of the CR properties in Walton County without any entitlements, without development rights at that point.
So it sounds like that there was a legal argument made to the director that determination in and of itself would divest developers from their what they believed entitled rights to the property.
That's right.
So you then authored a new determination.
That's right.
Taking that into account.
I did.
Okay. Can you walk us through that determination?
Yeah, again, my predecessor asked me to look at the previous determination and some of the specific language and if there was any room in the previous one to address the concerns that were brought to him. Go ahead.
So in your opinion as a planner and authoring both of these determinations, did that determination, that initial determination that was done, did it unintentionally go farther than what was the original intent of that determination in the language and the way it was written?
Not quite understanding the question.
Was it broader than what you thought that you were writing when you initially did it?
I mean, the outcome of
Right.
that, potentially, yeah, in some sense, I think so.
So you wrote the new determination, and explain to us what the change was with the new determination versus the old one.
So specifically, I was asked to look at what could be determined as open space in light of the language in the comp plan and the land development code, in trying to preserve what would be entitled rights under the zoning district. Make any necessary changes that were appropriate.
And do you still stand today with the changes that were made were appropriate?
They were in line with my predecessor's direction, certainly.
I don't have any other questions.
Mr. Tatum, go ahead.
Yes, thank you, Your Honor. Mr. Scholin, Mr. Arline made a big deal about the ensuring developer entitlements language, or maybe not developer entitlements, I think that's the way he phrased it, that's included in the director's determination. I've highlighted that paragraph. Could you read it, the entirety of it, please?
Out loud?
Yes,
Can you
please.
just tell me which determination you're reading from?
I'm sorry. This is the director's determination that was issued in 2025, whatever, I think it was February of 25, February 10th.
Okay, and
This would be the amended version?
And this would be on page 2, second to last paragraph.
It should be, also be noted here that there are entitlements associated with the conservation residential land use that must be considered and, in many instances, protected, provided the intent of the conservation residential land use and zoning can be addressed. It is with this in mind, as well as amendments to Florida statutes and administrative code relating to stormwater, and the above-mentioned objective language that staff has considered the subject further.
So it is not just about entitlements that this director's determination changed from the original.
Correct.
And does it not say in that paragraph that the intent of the conservation residential land use and zoning should be addressed?
It does.
Okay, all right. I have nothing further. Well, hold on. I did have some notes for you earlier. Oh, I have a question. Is there a process for appealing a director's determination in Walton County?
I mean, it is an administrative decision, and once issued, I believe within 30 days, it can be appealed as any other administrative decision.
And to your knowledge, has any appeal been filed as to this director's determination?
Not to my knowledge, no.
All right, that's all I have. Thank you.
Mr. Arline?
Hello, Mr. Sean.
Good morning.
Terrell Arline, represent SWCC. I'm going to go over the two directors' interpretations for you, and they're attached to this booklet I'm giving you as a composite exhibit 5. The first one is 2024, and the second one is 2025. What is your opinion of the intent in the LD's Land Development Code of the conservation residential zoning category?
Of the...
In the LDC,
In the LDC.
of the
zoning.
conservation residential zoning category.
It is to implement the conservation residential land use.
Now, you say that you wrote the first opinion, which was 2024. Is that right?
I did.
And on page 2 of that exhibit, you write, in the context of the conservation residential future land use and corresponding zoning districts, it is with the above notions in mind that it has been determined that the phrase open space, as defined in Chapter 9, only applies to continuous woodlands, wetlands, farmlands, environmentally sensitive area, floodplain, marshlands, protective vegetative communities, and wildlife habitat, or some combination of the above, that is set aside and not developed and placed in a conservation easement. You wrote that.
I did. I will say just one correction. That's not continuous. That's contiguous woodlands. Yes.
Contiguous, I'm sorry. But that paragraph does not speak to locating stormwater ponds in the open space areas of conservation residential, does it?
It does not speak to that, no.
And at that time, that was your recommendation, and the director accepted it, that that stormwater ponds would not be allowed in the open space area of the conservation residential.
It was not considered at that time, no.
But would a stormwater pond have met the criteria that I just read in the open space area?
It wasn't indicated there, so no, that would not have been considered, no.
Now, the second interpretation was dated February 2025, and that states that it's amended, I guess, the 2024 interpretation. Is that right?
Correct.
And you drafted that for the planning directors to approve?
Correct.
And in fact, didn't it broaden the type of uses that could be allowed in the open space area of the conservation residential from what was previously authorized in the 2024 interpretation?
It did.
And on page 3, if I may approach, of the 2025 determination, director's determination, paragraph 1, those uses were expanded from what you guys were recommending in 2024 to include wet detention ponds, correct?
As well as landscape buffers and recreational areas with the that abut permanent open space, yes.
Is a wet detention pond a stormwater pond?
It is, yes.
So the second opinion meant that in the conservation residential zoning categories, 60% open space requirement, that the applicant could install stormwater ponds in the open space area, right?
That was the result, yes, sir.
You believe that this second interpretation from 2025 is correct and in line with the intent of the Land Development Code on conservation residential zoning categories?
I believe it was in line with the direction I received from my predecessor. I believe there was considerable thought put into this and conversations in order to preserve as much open space as could be preserved, while also considering entitlements to the land.
Was, you stated, and I'm putting, don't quote me, I don't mean to put words on your mouth, but the second interpretation was created after being contacted by engineers who work for developers that asserted that all lands in the conservation residential category could not be developed due to the new stormwater standards?
That was a concern that was related to my director at the time, yeah.
Do you agree with that? That all lands in the conservation residential zoning category can now not be developed because of the new stormwater regulations?
I believe the stormwater requirements at the state, those adjustments in conjunction with the original proposed or originally signed determination, those two together would have created a burden and some hardship in meeting or allowing those engineers and developers to get to where the code would allow.
To get to the maximum development potential.
To get to the maximum development potential, yeah.
But your job as a AICP planner is not to ensure the maximum development potential of a site, is it?
No, it's not.
Did anybody ever come to you after this second opinion and tell you that they cannot develop their land in conservation residential because of the stormwater ponds? They can't put any development on it?
After the second was issued?
Yeah.
No.
Or before that?
before the second determination was issued, there were conversations certainly had that relayed that.
Right.
That sentiment.
Were there any examples given to you of, or development applications that were submitted that could not authorize any development on the conservation residential site because of the stormwater regulations?
There were some examples given to my director in conversation, I believe, yeah.
But
Specific examples, development approvals or DO applications received, I can't speak to that.
you're familiar with this area, Chat Holly, where this project's proposed, right?
Absolutely.
And there's a lot of 10-acre lots out there.
There are.
And a lot of those lots are either vacant or they're developed with one single-family home, correct?
Yeah, that sounds relatively accurate, yeah.
Can't the applicant here today go out there and put a single-family home probably and meet all the requirements of open space on each lot?
I suspect so.
In your opinion, should the conservation residential lands be clear-cut for the development of a stormwater pond?
No.
No. And that would have to happen here because this site is heavily vegetated, correct?
Yep.
I have no more questions. Thank you.
All right.
Your Honor, if I could, since he basically just did a direct, can I cross again?
I'm going to let the county go
Oh, she-
first.
No, the county has no redirect.
Okay, and I have a couple questions, so let me just ask them, and then I'll let all of the attorneys follow up on my questions. If you could go back to the February 2025 opinion, and you were asked to look at the paragraph on page 2, and you refer to amendments to Florida statutes and administrative code. And I don't mean to test you in any way, but do you have any citations or specific issues that were amended in those statutes or codes?
And I did briefly speak to it. It went from a quantity standard to a quality standard, which necessitated, based on information provided, up to 3 times the size of pond volumes to be able to meet those state standards. So that, in conjunction with the open space clarification, again, served to create some burden.
But there was no clarification in the statutes or the code as to what open space is.
In the statutes, no, and in the LDC, no.
That's all. I just wanted to clarify that for myself. All right. Mr. Tatum, do you have any follow-up, Ms. Davis, on my question? Did you understand my question?
I did.
Okay.
As far as the Walton County code language for open space, has there been any recent changes as to that definition within the land development code?
Not to my knowledge.
One more question, Mr. Schoen. Prior to the 2024 determination, how was open space looked at in the Conservation Residential Zoning District?
The same way it is written in Chapter 9.
And do you happen to have a copy of Chapter 9 in front of you that has the open space definitions?
Is there a copy of that in this booklet? I don't know.
Staff have one. Here you go.
Okay.
Can you read that definition for us, please?
It is the amount of the site that is devoted to recreation, resource protection, amenity, and/or landscape buffers. Open space may include, but is not limited to, lawns, decorative plantings, walkways, active and passive recreation areas, playgrounds, fountains, swimming pools, wooded areas, and water courses.
So prior to the 2024 director determination, open space in the Conservation Residential District could actually include impervious area. Is that correct?
That is correct.
I heard stormwater, or I heard swimming pools in there?
Swimming pools, yes.
Okay, all right.
Sidewalks, yeah.
Okay, all right. So what happened in 2024 was an attempt to comply with what was perceived to be the intent of the Conservation Residential zoning. Is that correct? Okay. And then what happened in 2025, the amended director's determination was a clarification in order to not unduly burden those properties. Is that correct?
Sounds accurate.
Okay, all right. I don't think I have any further questions for you. Thank you.
Okay, thank you.
Mr. Arline,
By
by me or by Mr.?
by Mr. Tatum. You just discussed the definition of open space in the LDC glossary,
That's correct.
correct? Now, isn't there a more specific definition of open space in the residential conservation zoning category?
Conservation residential?
Yes, sir, I'm sorry.
I don't know that there is a definition of it, but there is verbiage in there that speaks to what would be considered as such under that zoning category, yeah.
Yeah, I'm going to show you, and I can't pass it out now because I don't have a copy, but we'll get to it for sure.
Can you give me the citation?
2.02.02G is in green of the Land Development Code, paragraph 1. Special development standards. Could you read paragraph 1 to us in the record?
A minimum open space percentage of 60% must be provided that is consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland.
And that's narrower than the definition of open space in the glossary that you just discussed earlier, correct?
I'm not sure that I would, again, I mean, it certainly is. It is a more narrow description. I wouldn't call that a definition, but yes, it is. It describes it in fewer details, I guess.
But this is the special development standards for the conservation residential zoning category, requires 60% open space. And it doesn't mention stormwater ponds at all, does
It
it?
does not.
And was this provision of the Land Development Code in place when the Planning Department Director adopted the 2025 interpretation?
Yeah, there's been no change to the CR zoning since then, or
I
since.
have no more questions.
All right. Ms. Davis, do you have any other witnesses?
No, Your Honor, I don't.
Okay. Mr. Tatum? Are you ready to proceed? Does anybody need to take a break? All right. Mr. Tatum, go ahead.
Thank you, Your Honor. Again, for the record, Stephen Tatum here on behalf of the applicant. Give me just 1 second. We have a couple of housekeeping things I need to attend to first. Couple of items that I believe need to be in the record, although they're not pertinent to the open space discussion, but they were part of the application, are the traffic report for this particular project, the cultural resource assessment, and the 2 environmental assessments that were performed for the 2 parcels.
Okay, and they are not part of the agenda item?
They are not. There would be applicants exhibits 1, 2, 3, and 4.
Okay, and just to also, since we're doing housekeeping, I'm assuming that SWCC would like their Exhibit 5 admitted into evidence?
Absolutely, we're okay with that.
Okay, so SWCC Exhibit 5, which is the planning director's interpretations, have been admitted. And then the applicant's Exhibits 1 through 4, and you've given it to the clerk.
I have, and if you would like a copy, I have a copy for you, or
The trees are dead, so.
it's like we're sitting here arguing about environmental stuff as we kill the trees.
All right, thank you. And the traffic report is 1, applicant Exhibit 1, applicant Exhibit 2 is the cultural resource, applicant number, Exhibit number 3 is E-Tech consultant report, which is the environmental consulting report.
That is correct. There should be 2 of those.
Okay, and so the one
on one second, I'll
Okay.
give you the date. So, Exhibit 3
Is there?
is, I'm trying to think, well, there should be, maybe at the end.
Okay, it says version, no.
Okay, so Exhibit 3 is dated 5/27/25 on the last page.
Okay, so that's Exhibit 3, applicant's Exhibit 3, Exhibit number 4 is dated,
9/19/23.
all right.
Okay, before I call any witnesses, I would like to do a brief, well, it may not be too brief, but an opening, because this case, I don't normally do openings in these administrative hearings like this, but this particular case is really about statutory interpretation, which, as you know, is a legal issue, more so than a fact-intensive issue. So if you're okay and will allow me, I would like to walk through maybe about a 4 to 5 minute brief opening.
Okay, I also think it might be helpful if, and I don't know if the ordinance allows for this, but I know that the county has provided a proposed recommended order. If Mr. Arline or you, Mr. Tatum, on behalf of your clients, would like to provide a post-hearing submission.
I absolutely would like the opportunity to do that.
Okay.
Same with SWCC.
Ms. Davis, I don't have the ordinance in front of me, but
As far as a memorandum, or as far as
no,
a
it
new
would be
proposed final
it would be a
order?
proposed order, just as the county has already provided. And I would allow the county to amend theirs if they would like.
Okay.
I don't know if that's been done before, but it seems like this is.
Once.
The only concern is then the time limits that are required in the ordinance. The only other time that we have done this, there was an enlargement of time that was provided. So there was 30 days for each party to provide a proposed final order, and then there was an additional 30 days from that date
To provide my recommended.
correct.
Yeah.
So I think because it is written in the ordinance that you would have to provide your order within 20 days of the conclusion of this hearing, then we definitely would have to stipulate, because any changes would have to be in writing to the ordinance. So, but if the parties stipulate, I think we would have the ability to do that.
Well, we agree to, I guess that'd be a 40-day extension, because she has 20 days normally to provide it. So if we go 60 days, 30 for providing the order, and then 30 for her to determine, that would be 60 total, so a 40-day extension.
Okay, and I'm not gonna do a written order of enlargement, we're just all gonna agree.
We got a handshake agreement.
Well, it's on the record, so. All right, thank you, Mr. Arline and Ms. Davis. Mr. Tatum, I didn't mean to cut you off.
No,
just,
no, I'm glad you did.
Yeah, I just thought I'd clarify that.
Saved me from having to actually ask for that. Also, I did provide to the county and to Mr. Arline a legal memorandum regarding the interpretation of the open space. I'm going to, since we don't have a way to file it here necessarily, I'm just going to provide you a copy, give the clerk a copy, and I have 2 copies for the.
Okay, and what I would encourage you to do is put it in a form that, in your recommended order,
Okay.
that you would include it in the conclusions of law
Okay, all right.
section.
Okay, if I put it in the record still? Or what?
It's not evidence, it's already.
That's true, it's not evidence. All right, yeah, we won't worry about it, you're right. We can just handle it in the PRO. Okay, so with that done, now, if it's okay, I will proceed with my opening.
Yes, go
Okay,
ahead.
all right. First of all, thank you for taking the time to be here. Of course, I've said I represent the applicant, and I think I need to walk you through our legal position in this particular case. As you've heard today, this is a 20-acre site in Walton County. It's a low-density development. The zoning district it is a low-density zoning district. It allows up to 2 dwelling units per acre. We are providing 39 acres, so we're just under that threshold. There doesn't seem to be any issue today with this project except for, can the stormwater ponds be included in the open space calculation? So that's what I'm going to focus on. That's what most of our witnesses will be focusing on as well. It's the entire dispute, honestly. As you've heard, the applicant has complied, county confirms, with all required land development code regulations, comprehensive plan. This includes the director's determination. I think it's important to note that the director's determination from 2025 is authoritative. It is what we are here to follow. We have nothing else that we can follow besides the director's determination and the land development code. To understand this dispute, as they've already walked through the definition of open space for you, but we need to focus on what that open space requirement in 2.0209G1, which is the conservation residential open space requirement. It is not a definition, despite what the opposition would have you believe. It is a qualitative restraint on what can be considered open space. The open space definition still rules in every land development or in every zoning district. The question in conservation residential zoning is that open space use that is listed in the open space definition consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland? So the question, of course, is, what does that mean? And do stormwater ponds satisfy that? In Chapter 9, the LDC, Land Development Code, defines open space in its glossary. Mr. Schoen read you that definition earlier. But it includes such things as lawns, decorative plantings, walkways, active and passive recreation areas, playgrounds, fountains, swimming pools, wooded areas, and watercourses. Very broad definition because it does not limit it to that. It just says it can be those things. It's intentionally broad because to take everything into account that could possibly be open space and name that use out specifically would be next to impossible. The glossary definition applies across all zoning districts, and the CR 2-to-1 requirement is a specific quality requirement. What 20209G1 tells you is what the character of the open space must have in the conservation residential zoning district. What 20209G1 does not do is list any specific uses that are permitted in the open space area. It does not list any specific uses that are prohibited. It does not say open space shall consist only of woodlands, wetlands, or undisturbed natural land. It does not mention stormwater ponds at all, not to allow them and not to exclude them. It simply requires that whatever is provided must be consistent with the conservation of those listed resources. Now, that matters because, as you've heard, the opposition is arguing that stormwater ponds are implicitly excluded, but there is no exclusion in the text. And there is a standard in the text, and it's a consistency standard, and we will show that the ponds meet those standards. We believe, of course, that we know what that particular code section means. South Walton Community Council believes they know what it means, and of course we don't agree. And then we have two directors' determinations that are basically in opposition to one another as well, that were issued less than a year apart. So at best, you could say that language is ambiguous. If certified planners cannot agree on the meaning. Some of this stuff we have already dealt with, so I don't want to bore you and belabor the issue. So the stormwater ponds, they capture runoff, they allow sediment and pollutants to settle out. They support biological treatment through aquatic vegetation in what are called littoral zones along the pond's edge. You'll hear more about those later. And then they release that treated water at a controlled rate. And this does two things, serves two purposes. It's flood control and it's protection of the quality and quantity of surface waters. This is required by the Florida Department of Environmental Protection and the water management districts. The Walton County Land Development Code expressly recognizes stormwater ponds as conservation uses. That is in section 2.0300A. And probably to help guide you a little bit, 2.0300A is a table, and there's lots of different primary uses listed there, so you'd have to go down to conservation uses to see stormwater facilities listed there. So in other words, the code itself, so the same code we're here to interpret the conservation residential district, it classifies stormwater retention as a conservation use. If the code calls it a conservation use, it's difficult to argue that that's inconsistent with conservation. I mentioned earlier, or asked Mr. Schoen earlier, about if an appeal was ever filed to the director's determination. Our contention that the Land Development Code's appeal requirements are such that if they did not appeal the director's determination, they can't challenge it here. There is a process in place that must be followed. They did not follow that provision. Instead, they decided to collaterally try to attack our project. However, we do have two director's determinations, and the current one is the current operative official agency position. It is what has guided development and conservation residential since it was adopted. Applicant had no choice but to comply with it, and it's the authoritative construction of the code provision at issue here. And although we don't have Chevron deference anymore, we do the agency's determination of what their codes and regulations mean. It's given great weight in interpreting those particular provisions. Returning to the ambiguity question, stated before, we have two professional planners in the same office with the same training, reviewing the same provision, and they reached opposite conclusions. We had, and actually, if you think about it, there's been three interpretations. There was the original interpretation Mr. Schoen testified to from prior to 2024, when open space and conservation residential followed the strict definition of open space that is provided in the glossary, and swimming pools and impervious areas were allowed as open space. Then in 2024, we had a new interpretation that was very, very restrictive. Then in 2025, another interpretation that opened up, released some of the restrictions created by the 2024 provision. If that's not ambiguous, I don't know what is. If Walton County, who is their code, wrote it, then they should be able to tell you what it means. Yet they changed course twice within less than a year between the two directors' determinations. And since it's an ambiguity, in Florida law, that has legal consequences. The Florida Supreme Court, in a case called Rinker Materials v. City of North Miami, this is 286 Southern 2nd, 552, stated, since zoning regulations are in derogation of private rights of ownership, words used in a zoning ordinance should be given their broadest meaning when there is no definition or clear intent to the contrary, and the ordinances should be interpreted in favor of the property owner. So here we have ambiguous code provision. Seems to be a lot of questions about what it means. My client's just trying to comply, and SWCC is trying to, well, halt the project through a challenge to the director's determination in this particular forum. Okay, I believe the rest of this we've covered, so Your Honor, I'm going to call my first witness. It's going to be Mr. Nolan Baker.
Let me swear you in, hold on. Nolan, N-O-L-A-N, right?
Correct.
You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
All right. Mr. Tatum, whenever you're ready.
All right, Mr. Baker, will you please state your name and address for the record?
Nolan Baker, P.O. Box 522, Defiant Springs, Florida, 32435.
Okay, and is this your CV?
Yes.
I have copies of all of my expert CVs that can put in the record if that is okay with Your Honor. Any objection from?
No objection from the county?
No objection.
This would be applicant's exhibit 6. Okay, Mr. Baker, could you give us a brief rundown of your education background?
Yes, I obtained a bachelor's of civil engineering degree from Auburn University in 2001, and then went on and obtained my master's from Auburn University in civil engineering in 2003.
Okay, and what licenses do you hold?
I'm a professional license, professional engineering license in civil engineering in the state of Florida and one in the state of Alabama.
And the licenses are in good standing and current?
That's correct.
Okay. What experience do you have working in civil engineering?
I've been working in civil engineering 27 plus years throughout the Southeast, primarily in the state of Florida.
Okay, all right. What was your involvement in this project?
The engineering record.
Okay, and as engineer of record, did that mean that you oversaw the design of the project?
That's correct.
Overall site plan layout?
Yes.
And the stormwater design?
Yes.
Okay. At this time, I would like to tender Mr. Baker as an expert in civil engineering with particular expertise in stormwater system design and permitting in Northwest Florida.
Okay, are there any objections?
No, Your Honor. Mr. Baker's previously testified in that capacity. Except for the permitting, I don't know that he's testified as an expert in that specific, but I know he has extensive experience in it.
Okay, I'm going to accept you as Mr. Baker will be accepted as an expert in engineering and stormwater, and I'll reserve. I don't know if we need you as permitting, but go ahead, Mr. Tatum.
All right. You could describe the overall stormwater system at the preserve at Santa Rosa Beach.
It consists of two wet detention ponds, one on the north side and one on the south side of the property. The stormwater in general from the lots, front half of the lots drain to the roadway where it's collected and conveyed to the stormwater systems, and the rear half of the lots in general, sheet flow off the back of the lots into the adjacent pond through the buffer that we're going to provide.
And what's the total acreage of those ponds?
See, pond 1 was 2.9 acres and pond 2 is 3.1 acres.
And what engineering standards did you use in sizing and designing the ponds?
Those were the requirements as specified in the Walton County Land Development Code, as well as the requirements of Water Management District, which was the Northwest District.
And what primary functions do these ponds provide?
Water quality and water treatment. And I would like to add in addition, on this project in particular, since it's in a flood zone, we had to provide flood control as well, yes.
So these ponds are a permanent feature of the site?
Yes, they are.
Okay. And they are wet retention ponds, is that correct?
That's correct.
All right. Was there some question about a note in the plans that said they were dry retention?
Yes, I saw a question about a note on C 1.1, which was a note that wasn't changed. We didn't change the word from dry to wet, but all the applicable verbiage applies.
So that was just a kind of a boilerplate note that was?
That was just a typo, yes.
All right. So these stormwater ponds, they have no impervious structures within them, is that correct?
That's correct.
Okay. Are the ponds accessible and visible to the residents in that neighborhood, assuming the neighborhood gets built?
Yes.
Oh. One last question. I believe we've handled everything else we need. I'm going to hand you what we will hope is applicant's composite exhibit 7. Yes, it is. Do you recognize that document?
I do.
Your Honor, what applicant's exhibit 7 is it's a composite exhibit. It's 3 aerials dating from the 1940s, one from 1999 and one from 2024. Did you prepare these?
I did.
Okay. Where did you pull the aerial imagery from?
The 1940s aerial, the first page was pulled from FDEP website.
Excuse me.
Okay.
And then the 1999 aerial was pulled from historicalaerials.com. And then the 2024 aerial was pulled from the Walton County Property Appraisers site.
Okay, all right. So I would like to enter these as applicant's composite exhibit 7, if there's no objection.
Are there any objections? You want to look at them before you decide whether you want to object or not?
No
Ms.
objection from the county.
Okay. I'm sorry, can you just tell me again where you got the 1940 from?
1940 from FDEP.
FDEP. Mr. Arline, did you say whether you had an objection or not now? All right, thank you. So Exhibit 7 is accepted into evidence.
Yep. Mr. Baker, given your experience with site design in Walton County, civil engineering design, is it your position that this project complies with the applicable regulations?
It does, yes.
Walton County Land Development Code?
Correct.
And the
Yes.
comprehensive plan?
Yes, sir.
Okay. I don't have any further questions for Mr. Baker at this time.
Ms. Davis?
I don't have any questions at this point.
Okay, Mr. Arline?
You know how big the 2 stormwater ponds are that are proposed on the engineering plans?
Yes, sir. I just stated that.
What's the size?
Was pond 1's 2.9 acres, pond 2 is 3.1 acres.
And those are included in the 60% open space for the conservation residential category?
Yes, sir.
And if you went out there now today and looked at the site, would you agree with me that it's heavily vegetated, the whole site?
Yes, sir. It's wooded.
In order to build those 2 stormwater ponds, you're going to have to clear cut all of that vegetation and habitat, and right, to start to build the stormwater ponds.
Yes, sir. You would have to clear the area of the stormwater ponds.
And then you're going to have to dig out all the soils to get to the depth that you need for the stormwater pond, right?
Yes.
So the conservation, the natural areas, the environmentally sensitive areas, the habitat that's there now is going to be destroyed in order to build these 2 stormwater ponds, except for the one
Well,
wetland.
it depends on what you define as environmentally sensitive, so. I mean,
Okay. What about natural areas? Isn't that, all that vegetation natural areas?
well,
he's not
I'm not that.
qualified to answer whether it's a natural area or it's
Okay, I'm gonna ask you to move on, Mr.
Okay.
I'll sustain the objection.
No more questions.
Okay. Mr. Arline, do you have any witnesses that you'd like to?
Oh, I'm sorry, no.
Oh.
Nothing further from Mr. Nolan.
Oh, I'm sorry. I misunderstood. Okay. Mr. Nolan, Mr. Tatum, who is your next witness for the applicant?
Next, I'd like Ms. Ekblad, Tina Ekblad, to come forward.
Give me your name again.
Tina Ekblad, Ekblad.
All right, and I will be qualifying Ms. Ekblad as a expert in land use planning with particular, oh, I'm sorry. You need to
Let me swear you in.
Yeah.
You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
Right.
Okay. Seeking to qualify Ms. Ekblad as a expert in land use planning with particular expertise in Florida land development regulations, comprehensive plan, consistency analysis, and the Walton County Land Development Code. So, Ms. Ekblad, please give us or testify as to your education.
Sure. I have a Bachelor's of Arts with a focus in environmental science from Florida Gulf Coast University in Fort Myers. I also have a Master's of Public Administration with a concentration in environmental policy from Florida Gulf Coast University.
And how does your academic background in environmental science and policy inform your work as a land use planner?
Well, I actually started more in the ecology side through my academics and shifted into the policy. So it gives me a little bit more of an understanding as it relates to the growth management legislation in the state and how that came out of environmental regulations, and then how that creates the policy environment that we work in today. And it helps me better understand the assessments that the ecologists prepare and the site design that the civil engineers put together and how they relate to one another.
Are you AICP certified?
I am.
When did you receive that certification?
In 2011.
And is that certification current and in good standing?
Yes.
All right. What does it require? What does an AIPC certification require in terms of professional standards, ethics, et cetera?
So AICP is the American Institute of Certified Planners, and it is a national exam to determine whether or not you have the appropriate qualifications for land planning. Depending on what your educational background is, you are required to demonstrate a certain level of professional experience before you can even sit for the exam. So in my case, because I have a master's in public administration, I had to demonstrate a minimum of 4 years of full-time employment in the field of land use planning. Then you are basically given an invitation to sit for the exam, which you still have to pass before you obtain your certification. Once you have that certification, you are required to complete 32 credit hours of continuing education every 2 years. Those credit hours are required to be in various topic areas: ethics, law, sustainability, diversity, equity, and there's one more that I've forgotten. With regards to ethics, there's a specific ethics policy for planners. Our opinions are not allowed to change whether we hop from the public sector or the private sector unless there are certain documented conditions. And there is an ethics board where, we can report unfortunate events and have investigations on professionals. And that has occurred in the state, unfortunately.
What is the current position, or what is your current position in the name of your firm?
I'm the founder and principal of Sage Entitlements.
What's the general scope of your current planning practice?
I provide land use planning consulting services to property owners, developers that are seeking to develop and redevelop property. And my practice area is in industrial, commercial, residential, mixed use. I'm a qualified expert in historic preservation. I also serve as an expert witness for land use litigation and eminent domain cases, and I coordinate with several local governments regarding text amendments to the Comprehensive Plan and Land Development Code.
Have you worked specifically on other Walton County matters?
Yes.
What year did you begin working in Walton County?
I started practicing planning in Walton County in 2012.
What expert witness background do you have?
So I'm qualified in several jurisdictions across the state, quite a few in Southwest Florida where I began my career. And then in this portion of the Panhandle, I'm qualified as an expert in Walton County, Bay County, Leon County, City of Tallahassee. I think that's it.
All right. At this time, I would like to tender Ms. Ekblad as an expert in land use planning with particular expertise in Florida land development regulations, comprehensive plan consistency analysis, and the Walton County Land Development Code.
Okay, are there any objections?
No, Your Honor, I just don't know that it's necessary to have the specific subcategories. I would stipulate to Ms. Ekblad being an expert in planning.
Okay, I'm going to be consistent with all of our experts and just deem you an expert, accept you as a land use planning, land use and planning. I believe that that's what we've done our other ones, and but you're welcome to testify anything in that range. And
that's acceptable. All right, thank you, Your Honor. Ms. Ekblad, is this your CV?
It is.
All right. This is applicant's Exhibit 5. I've provided it to the parties. If there's any objection, otherwise I'd like to enter it into the record.
No objection.
Exhibit 5 has been accepted into evidence.
Ms. Ekblad, you've had an opportunity to review the director's determination, 2 director's determinations in question. Is that correct?
Yes.
In order to get to that, let's talk about this. Can you give me, I know I've had it read into the record before, but again, what is the definition of open space that is in the glossary of the Land Development Code?
Yeah, so Chapter 9 of the LDC is the glossary. And in that chapter, open space is defined as recreation, resource protection, amenity, and/or landscape buffers. And then it states that lawns, decorative plantings, walkways, active and passive recreation, playgrounds, fountains, swimming pools, wooded areas, and water courses may be included. And it indicates that that's not an exhaustive list. It is not limited to just that list.
Does the LDC definition expressly prohibit stormwater ponds?
It does not.
Okay. In your planning practice, is it standard for stormwater ponds to be recognized as a component of an open space system?
Yes, in several jurisdictions that I work with, open space is permitted to be included, stormwater management ponds are permitted to be included in open space calculations, and several municipalities that I work in have requirements for how you show that on the site plan and then how it's designed and things of that nature.
Does the Walton County Land Development Code provide a definition for conservation uses?
Yes.
What does that include?
So the definition in Chapter 9 is a bit circular. It points you back to LDC Section 2.03.00. And that section in 2 states that conservation uses are, quote, activities or conditions within land areas designated for the purpose of conserving or protecting natural resources or environmental quality. And then the definition goes on to state areas for flood control, the protection of surface water, floodplain management, commercial or recreationally valuable fish and shellfish, or protection of vegetative communities and wildlife habitat are also included.
Does the conservation residential 2-to-1 zoning district permit all types of open space listed in the open space definition found in Chapter 9?
So I agree with Director Schoen on this front, it provides a lens that you're supposed to review the definition in. And so all open space as defined is permitted, but you have to demonstrate consistency with the 4 types of habitat or items, I'll say, that are listed under the Conservation Residential Zoning District. You want me to walk through that?
Yeah, if you could.
So, to give you an example of how that's more limiting, the open space definition includes things like fountains, swimming pools, an amenity could be a clubhouse. All of these things are impervious improvements to the land, and it is my professional opinion that those types of open space are not consistent with the 4 items that are identified in the special standards of the zoning district. And so those would not be included in the 60% calculation. And this framework starts with the intent of the zoning district. The LDC specifically states that the intent of conservation residential 2-to-1 is to address development constraints. And then it defines them as a list of things that includes wetlands, floodplains, salt marsh. And it is these things that effectuate the limited low residential development. The proposed development order is consistent with the low residential development. We've heard already that it's within the 2 dwelling units to the acre and actually less due to the wetland impact. And so when we're looking at designing that low impact residential, we then have to go to the special development standards and think and look at the environmental assessment and determine, are there natural areas on site, environmentally sensitive lands, habitat, or farmland? And then depending on whether or not those things are there, going to the open space definition, what is consistent in that definition with these items? So passive recreation would be consistent with those items. A walkway that is not concrete would be consistent with that item. There are several communities in Walton County that have pathways that are not like a sidewalk type of thing. Those items would be consistent with these 4 listed in the zoning district and can be counted towards open space.
So the open space is demonstrated on the applicant's site plan. Does it, in your opinion, meet the open space definition?
It does, and it also excludes things that we could count, like lawns, playgrounds, decorative plantings. Those types of things were not included in the calculation, even though they're in the definition.
So in your opinion, we actually could be counting more of the site as open space than what we have actually taken credit for?
Based on the definition, yes.
And just drawing from that legally, or rationally speaking, you're of the opinion that the stormwater ponds are also to be counted as open space in conservation residential?
Yes, I believe it can be demonstrated that our design is consistent with the 4 items listed in the special development standards.
Okay, so from a general planning standpoint, why is it appropriate to count stormwater ponds towards open space?
So I think we have to remember that open space is not just vegetation, right? The definition includes these other items, such as recreation and walkways, landscape buffers, which are enhancements to the property beyond the vegetation that is just there today. And so I think the stormwater management areas with the enhancements that we have proposed are consistent with those other examples in the open space definition. Keeping in mind, of course, that the open space definition is not exhaustive. It says includes but not limited to, and then the zoning district says consistent with. You're not just limited to natural areas, habitat, farmland, et cetera.
Okay. So let me clarify that just so I make sure I understand it. It's not your opinion is that consistent with conservation of natural areas, habitat, farmland, forget the 4th one at the moment, but does not mean that those areas that may be on the site cannot be touched and must stay in their current natural condition?
Yeah, so my opinion would be that you would have to look at the environmental assessment, and I believe you have Mr. Denzow who's going to speak to this, and evaluate the existing conditions of the site today. Does the site meet those definitions? Environmentally sensitive has a definition to it, right? Are those things provided on the site? And then create an open space plan that either includes the items or does not, because it does not exist. And I think it's important that we talk about what is on site today and how it got there and whether or not it meets these terms. It's my understanding in coordinating with Mr. Denzow that it does not. When you look at historical aerials, you take into account existing permits like ERPs and things of that nature.
So the consistency part of that open space requirement. I think I hear what you're saying, but I'm not sure I'm hearing what I'm thinking.
Okay.
If it's consistent with conservation of habitat,
Right, so.
would stormwater ponds be considered habitat?
Correct. Right, and I think the other thing is consistency is a positive or neutral benefit, right? So stormwater ponds do not have a negative impact on natural areas or the habitat as you're describing here, and are consistent with.
Would you describe the design of this project as clustered in a manner that protects the environmentally sensitive portions of the property?
I would. As I mentioned, environmentally sensitive lands are a defined term in Chapter 9. There's a laundry list of items. The only thing that is applicable to this site is the wetlands. We have preserved the wetlands, and the Water Management District has agreed that our impacts are appropriate.
All right. Overall, not just the open space question, but did you review the site plan in conjunction with the land development code for all aspects of the development?
Within the areas of land planning, yes.
And in your opinion, is it consistent with the land development code?
Yes.
And the comprehensive plan?
Yes.
All right. I have nothing further at this time.
Ms. Davis?
Ms. Cyclot, just a couple of questions, just to kind of clean up for a second. You kept using the word permitted pretty liberally. So when you're saying permitted, are you sometimes meaning allowed rather than like permitted, like there's a permit issued for something?
You said I used it a lot, and so I'm afraid to just say yes, because I clearly did it out of subconsciousness. I apologize.
So
if you give me an example, I'm happy to clarify.
Perfect. You said that you were talking about that allowing stormwater ponds as open space is permitted in other jurisdictions.
It is allowed. Yes, there are specific provisions in the land development code that if your open space calculations include stormwater management, then ABCD apply.
Okay, so it's an allowable use, not a permitted. It's not something that you have to apply for and get a special allowance for this to happen.
Yeah, I would not call it a use. It's not in the use tables, just like it isn't here. But yes, in that sense, I was using permitted as allowed. It is allowed to be included in the open space calculations.
Okay. Now, these other jurisdictions that you're speaking about are allowing the stormwater to count as open space. Would those be done in similar or some kind of equivalent zoning category as Walton County's conservation residential?
Excellent question. And the answer is yes. Multiple jurisdictions that I work in have environmental preservation overlays. And in those instances, we are allowed to count stormwater as open space. And again, there are certain conditions that need to be met related to the planting of the littoral shelves and things of that nature.
I don't have any other questions.
Mr. Arline?
Terrell. Okay, let's just start at the end. The other jurisdictions in the state that you're familiar with that allow stormwater and open space, that doesn't control what happens here today with this project under the Walton County Code, does it?
No.
Now, I want to show you the two provisions of, conservation that we're talking about here. Books. So this first page is a copy of 2.02.02 G1, which is the open space provision governing conservation residential, correct?
This document in front of me says notes and comments, Craig Diamond, 2.02.09, special development standards. So whatever he has copied here presumably is from the Land Development Code.
Familiar with the Land Development Code?
I am.
Do you disagree that that is what the code states?
I have a printed copy from the actual LDC if I could compare them.
Oh, let's do that.
Yes, it appears to be a copy and paste version.
Okay, and
Can you give me the citation again? Is it
it's 2.02.02 paren G paren, no, I'm sorry, 2.0209, my mistake, paren G paren 1. It states the minimum open space percentage of 60% must be provided, and this is the focus, I think, that is consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland. It doesn't use the term conservation use in this provision of the code, does it?
No, conservation uses are a primary use allowed under subsection B.
Right. So your testimony, okay, let's talk about subsection B. I have got Mr. Diamond's provision here. 2.03.00 is the category of primary uses you're talking about?
I don't know the citation. I'm assuming this is another copy and paste.
And the conservation uses, this provision that you're reading is contained in 2.03.00?
Again, I don't know the citation off the top of my head. I'm assuming this is a copy and paste.
Okay. Do you have it with you?
Sure.
.0300.
Yes, 2.03.00 categories of primary uses, and you want conservation?
Right.
Okay.
And then that begins with the term conservation uses.
Correct.
Now, isn't there a grammatical difference between the phrase, the terms conservation use, which I think is a noun, and the terms conservation of, maybe a verb?
I don't think it's appropriate for me to answer questions about English.
I agree with you, it's not hard.
If you want to ask her interpretation of the code, that's fine.
Okay. Do you think that conservation use means the same thing as conservation of?
In the code.
In the code.
I think that the conservation uses are a use that is allowed, and I think that that list of uses may qualify as open space that is consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland. I think a demonstration of consistency can be made.
Okay, and going back to 2.0300, the categories of primary uses, conservation uses, it also includes commercially or recreationally valuable fish and shellfish. Is it your position that you could put commercially or recreational valuable fish or shellfish in an open space area in conservation residential?
I think that as an applicant, that including it in the open space calculation, you'd make the applicant applying for the commercially or recreational valuable fish and shellfish would have to include a demonstration that that use being included in open space is consistent with the conservation of natural areas, environmentally sensitive land, habitat, or in this case, farmland.
Do you believe that clear cutting this site for the construction of these stormwater ponds is consistent with the conservation of habitat on the site?
I'm going to let Mr. Denzau speak to that because it's my understanding that the term habitat has specific meaning and he is the expert in the ecology on the site.
You testified before about how wetlands operated. You don't feel comfortable answering that question?
I said that there had been an approved ERP and that wetlands were included in the definition. I think that is a common understanding of how wetland impacts are permitted.
Okay, I have no more questions.
Can you just tell me what ERP is again?
An environmental resource permit was approved on this property by the Water Management District, FDEP. I apologize.
Okay, you don't have to testify about that. I just wanted to know what the ERP.
Environmental resource permit.
All right.
Yeah, just a couple of follow-ups. As far as the definition in 2.02, the conservation residential 2-to-1 zoning district, the open space requirement that is there. Since Mr. Arline opened up this door about grammar, which I know is not something we should be looking at with you, but
I did sustain your objection, so if you want to open that door,
I understand, and I'm not actually opening that door, but will you just read that section to me again, G1?
Yes. It states a minimum open space percentage of 60% must be provided that is consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland.
Okay, so I thought I heard that right. It doesn't say anything about clear cutting being allowed or not allowed.
It does not.
Okay, I have nothing else.
Thank you. All right. The applicants, you have another witness. I'm going to suggest that we take a break. It's 12:43, and 15 minutes. Is that okay?
That'll work, Your Honor, for us.
Okay. Do you need more? Oh, okay. You want to take a lunch break? Okay, if we're going to take a lunch. How about an hour?
Probably 45.
1:30.
We'll come back at 1. Well, we won't start with unless everyone's here, but let's shoot for 1:30. All right, we'll go off the record. All right, I believe when we took the lunch break, the applicant, you have another witness to call? Oh, okay.
There we go.
Got it. I can't hear you.
Now we can do it. All right. So, yes, Your Honors, this is, for the record, Stephen Tatum again for the applicant. I'm at this time going to call Michael Ekblad.
Good afternoon.
Michael, same spelling?
Yes, ma'am.
And seeking to have him qualified as a landscape expert in landscape architecture with expertise in littoral shelf design. Mr. Ekblad, tell me your education experience.
So I have a bachelor's in landscape architecture from Louisiana State University. Graduated in 2006. From that point, continuing education through licensure. Licensed in 2 states, have been practicing landscape architecture in Florida since 2006, and it's a body of knowledge.
Okay. And while at LSU, you received a College of Arts and Design Natural Systems Award. What did that award recognize?
Special recognition from the program for ecological design and analysis related to green site infrastructure solutions, such as using plants to stabilize extra steep slopes.
Okay. And you are a licensed landscape architect?
Yes, licensed in the state of Florida and Tennessee, Florida license number 6667058.
And that license is still in good standing?
It is.
All right. What's your current position?
My current position with O'Connell and Associates is Vice President of Operations and Landscape Architect for the firm.
And how long have you been practicing as a landscape architect?
Approximately 20 years.
If you could describe your practice.
Sure. The bulk of my work has focused on large-scale land development projects, including residential, industrial, and commercial developments, where I would act as either part of the project team or as the visionary and principal in charge of designing large-scale projects that focused on everything from site layout to environmental considerations for that. In doing that, it would not only be the initial layout for the development, but then also the detailed design there afterwards. So everything from amenity design to flowways and littoral shelves. Following that, it would be the permitting process that generally goes along with those development considerations, and then finally through to construction phase.
Okay, so based on that, your experience specifically includes design of systems with littoral shelves, wetland restoration areas, flowways, and habitat corridors. Is that correct? Okay. So describe your experience with littoral shelf design.
So I have a number of projects in the state of Florida that have used littoral shelf designs, flowway corridors, and recreated marsh habitats, specifically related to structure of developments. So that would include traditional stormwater ponds and littoral shelves that happen there, also mine reclamation, which would be enhanced littoral shelves that we have to then take into account. Action. Habitat created for different wildlife moving through the sites, as well as the restoration of those mines following excavation. Similarly with residential design and commercial design, working through how regional water systems work through the site, designing littoral shelves for not only active and passive amenities, but also the conveyance of water through those. One project in particular was the Esplanade Golf and Country Club of Naples, which was at the end of the Corkscrew Regional Ecosystem Watershed in Collier County, where a conveyance flowway had to flow through or bypass the site. But as part of that model, we worked with the engineers to create a number of different profiles for that flowway to incorporate everything from littoral shelves to deeper ponds and let that slow-moving body of water move through.
Okay, so when you say flowway, you mean a stream, essentially, or is there a different, what does that mean?
So it was the flow through that area had always existed, but we memorialized it in a channel basis. It was very slow moving. I would hate to call it like a creek or a river, but it allowed that conveyance to happen.
All right. And just so everybody understands, what is a littoral shelf?
A littoral shelf is the slope between upland and aquatic environments.
In what? When you say it's the shelf between...
So typically a littoral, the littoral area is that slope. A planted littoral shelf would be that shelf, but planted with herbaceous materials, generally native in the instances we're dealing with. And they would provide that transition from, somewhat above normal high water to below the water level, and a mix of plants everywhere from grasses to emergence to floating lily pads and things of that nature.
Okay. All right. All right, this time I would tender him as an expert in landscape architecture with an expertise in littoral shelf design.
Are there any objections?
Your Honor, I would just ask that he just be qualified as an expert. We don't have to do the specialized knowledge therein.
All right, I'm going to accept him as a landscape architect, an expert in landscape architecture. How's that? And obviously, that probably includes littoral shelf design.
Yes.
So.
Okay. All right. Okay, thank you, Your Honor. To begin with, we'll do the CV thing again. Is this your CV?
It is.
All right. This is applicant's Exhibit 8. There is a handwritten notation on there because we mistyped the Florida license number. So if there's no objection, put this in the record.
Applicant's Exhibit 8, is it admitted? Thank you.
Okay, now for the good stuff. Have you had a chance to review the preserves at Santa Rosa Beach project?
I have both the engineering drawings as well as a visit to the site.
And what were you retained to do in relation to this project?
I was retained specifically to design the littoral shelves around the 2 stormwater ponds.
Okay. And what documents did you review in preparing that design?
In addition to the engineering plans, the Walton County Land Development Code, and then various online resources ranging from the University of Florida's IFAS website, which is the Institute for Food and Agricultural Sciences, as well as approved plant lists and littoral design standards from other jurisdictions.
And you have visited the site?
Have.
Okay. What specifically did you evaluate regarding the pond and the littoral shelf design?
Specifically the location of the ponds on the site, the slope of the littoral areas, the area of each zone within that littoral shelf, as well as the normal water level of the pond depth, and location of drainage infrastructure.
And how do you go about determining what planning requirements you need to use?
In this particular case, the Walton County Land Development Code doesn't have a littoral specific design requirement, and so we ended up making, maybe not an assumption is too strong of a word, but tried to pull from other code sections that replicate the type of thing that we're doing here. So the code section we pulled from was 4.06.02, which is the restoration of natural areas if they've been removed without permission. And in that code section, it indicates that basically 100 plants per 1,000 square feet is the planting density that has to go back there. And then we use a mix of grasses, shrubs, other emergents, and trees to make that replacement.
Okay. So can you describe in a little bit more detail the littoral shelves that you've designed for the preserve?
Sure. The littoral shelves are a consistent 4-to-1 slope around most of the lake bank and swells behind some of the lots. As testified, they are collecting the water from the back of the lots, and that littoral shelf is meant to intercept that water going into the stormwater ponds as a means of filtering out debris as well as providing habitat.
So How does the planning plan you described replicate the edge conditions of a natural pond?
So within each littoral shelf, there are different zones ranging from above water to the aquatic state. And so within that slope, there's a natural gradient based on the plant selection and how they survive in those various depths. And so that's going to replicate what a natural system would do, because we are basically using those same native plants that exist in other areas like that and just applying it to this slope.
Okay. Does that sort of design facilitate the creation of habitat?
It does.
Once established, with the proposed littoral shelf planning plan, how would it look compared to a natural pond edge?
Sure. So the plant species, like I mentioned, would all be similar from other plants around the state or other conditions like that around the state, both native and, of course, man-made. Other than the uniform slope, it would essentially look and act the same way.
Okay. Do these littoral plantings provide screening and buffering functions?
Both visual boundaries. You can obviously see the difference between the non-littoral area and the lake, but it also collects debris, trash, sediment, so it also acts as a physical buffer.
All right. In your professional opinion, does a stormwater pond with a fully planted littoral shelf provide the open space consistent with the purposes of the CR 2-to-1 district?
Based on the testimony of Ms. Ekblad, I would agree that it does.
And is there any professional or regulatory basis for treating such a pond as something other than an open space?
Not in this instance, in my opinion.
That's all I have at this time.
Ms. Davis?
Mr. Ekblad, is any of this required by the county?
No, ma'am.
Okay, so there's no county safeguards that this is going to happen in accordance with the way that you've testified that you're intended?
I'm not sure I understand the question.
Does the county have any mechanism to make you or the applicant plant things according to what you testified that the intent would be?
I don't know what the mechanism is to get the littoral plant pulled into the development order. There is a note on the plans.
A note on the plans, I mean, that's not binding, is that correct?
I would argue that it is. It says the developer to provide credit to the builder for installing supplemental plantings within the ponds. So there's obviously a requirement based on the engineering plans that something be done in this area, whether or not it's my specific plan or something else.
That's just a request for the developer to give the builder credit, though, is that right?
As part of the approved
Right.
development.
If they do this, then the builder would get credit for doing that. Is that correct?
That would be my assumption.
Okay, and so is this a requirement of the stormwater plan, the plantings that you discussed?
Mr. Ekbal, if you'll just either, I know you're very tall, maybe just move the mic.
There we go. Sorry.
That's okay.
Is the littoral shelf and these plantings, you were talking in terms of stormwater, is this part of the stormwater plan in order for it to be sufficient?
The stormwater management system, based on the engineer's design, stands on its own. Littorals are often used to supplement those designs. In this case, I believe that it meets all the requirements of the Walton County Land Development Code as it sits. So this would be in addition to.
So it's not a requirement for the stormwater plan? Okay. And finally, I obviously, Ekblad is a very odd name, and you stated specifically based on the testimony of Ms. Ekblad. Mr. Ekblad, it's quite, you are married to Ms. Ekblad, is that correct?
I am the arm candy, yes.
Okay. Well, congratulations.
Okay. Mr. Arline, do you have any questions for this witness?
Terrell Arline, I didn't get that last joke, so.
Hopefully she did.
Talk to me about it later. You said, well, let me just ask you this. You discussed habitat. Is there currently habitat on the site of this development?
I would say yes.
And you mentioned natural areas, and is there currently natural areas on the site?
Based on the aerials that have been submitted, I can't qualify that they are indigenous natural areas, but they are composed of native vegetation. So in that case, I would say yes, they're natural.
And in the code that we've been referring to here, section 2.02.09 G1, it requires that habitat and natural areas be conserved. Take my word up on that, that's what we're arguing here today. And my question is, isn't the site and these natural areas and this habitat that's there now going to be clear cut and developed for the stormwater ponds?
I think first, I don't know the section of code enough to say that you're right or wrong. It's not something I've committed to memory. I'm certainly not a land use planner. Clear cut is a very broad term in the way you're using it. It sounds like you mean it to go from property corner to property corner across the whole site.
They're going to cut down trees and dig up the ground to build the stormwater ponds, correct?
Yeah.
And so that will be removing habitat and natural areas that is on the site now. So I may be reading into this, but your whole purpose of providing littoral shelf vegetation is to provide habitat and natural areas in the stormwater pond, right?
It is to augment the stormwater pond in a way that better provides those elements.
And here's my question. How many acres of the existing habitat and natural areas will be destroyed to build these stormwater ponds? And how many acres of your littoral planning will result in the ponds? Are you going to be putting less or natural areas and habitat than was there before?
Caroline, I'm going to have you break that question
Okay,
down.
I'm sorry. You're
Just
right.
so I can understand.
Okay. If you build your stormwater ponds and you install the habitat, the littoral vegetation that you're talking about, is that going to offset the amount of habitat and natural areas that are destroyed to build a stormwater pond?
I don't know that I'm qualified to make a comparison that it's an offset. I haven't done a calculation to say what the habitat value is today versus what it will be at the end.
What about just acreage?
Acreages of the stormwater ponds are listed on the civil engineering plans. Can you help me out with that?
Okay.
Well,
You want to rephrase your question, Mr. Arline?
do you know how many acres of the littoral zone you're planting in the stormwater ponds?
It's approximately 1.5 acres.
Okay. And isn't it true that the amount of the area that's existing there now of habitat and natural areas exceeds 1 or 2 acres?
I'm also going to object. It was not qualified.
Okay, he did testify regarding the environmental nature of the planting. So if you want to ask him about that, you can. Otherwise.
So isn't it true that your littoral planning does not offset the amount of plants and natural areas that are destroyed to build the stormwater ponds?
I can't quantify the number of plants that are out there.
You said, but your littoral area is how many acres?
1.5.
How big are the stormwater ponds?
Beyond the engineering plans.
Can you look at them and tell me what they are?
Okay.
Because he doesn't want the answer. He doesn't want.
No, you literally
answer.
asked Mr. Baker that question, and he answered.
Can you not argue with each other? I believe the testimony previously was that there was a 3.1 acre stormwater pond and a 2.9 acre stormwater pond.
And then there's how many acres of littoral area?
Is that right? Do you know?
The pond size?
Yeah.
Not without looking at the plans.
Okay, okay, go ahead.
So how many acres of littoral are you adding?
Approximately 1.5 acres.
Now, why are you doing the littoral planning in the stormwater pond? I mean, it's not required for the stormwater pond, is it?
It's not required in the current design.
And are you providing this littoral zone to mitigate for the impacts of the development on the existing native vegetation?
There is no requirement for the littoral plantings.
Okay. No more questions.
Okay, I have a question. And I will allow the attorneys to follow up on that. You were asked about the pond sizes, but you were also saying that your plantings will be 1.5 acres. Is that right? Is that in the pond or on the edge of the pond? I'm just trying to visualize
Sure,
it.
the littoral shelf is that transition from upland to the pond bottom. And so that's primarily where the plants are installed. How they migrate after that is up to nature.
Okay. That's all I have. Are there any follow-up questions? Go ahead.
Will the ponds themselves act as habitat?
Yes.
And what kind of species would you be likely to see within these ponds?
Frogs, wading birds, microorganisms, insects.
So the ponds themselves, although they're being characterized as only being 1.5 acres of habitat recreation, actually all remain a habitat? Or will become a habitat? Let me rephrase that question.
Yeah, the 1.5 acres is the littoral planting shelf. It's not a habitat. I'm not defining that as the only habitat. So it's inclusive of the water. That interaction between the upland and the aquatic environment is what helps with the habitat.
Okay, so the ponds themselves are a habitat?
Yeah.
Okay. I believe that's all I really need to get into. Thank you.
All right, thank you for your testimony. Mr. Tatum, do you have another witness?
Your Honor.
Okay.
I can call Dr. Mike Denzow.
Can you just spell your name for me so I can write it down?
It's Michael Denzow, D-E-N-T-Z-A-U.
D-E-N-T...
A-U.
A-U. And is it M-A-C-K or M-A-C?
Michael, M-I-C-H-A-E-L.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right.
Thank you, Your Honor. We'll be seeking to have Dr. Denzow qualified as a wetland scientist. Dr. Denzow, will you provide your education experience?
Yes, I have a bachelor's in biology and marine biology from Fairleigh Dickinson University in 1981. I have a master's in wildlife and fishery science with a focus on marine fisheries in 1985. And then I have a doctorate in curriculum instruction with a specialization in science education from Florida State in 2013.
And what professional certifications do you hold?
I'm a professional wetland scientist, certified by the Society of Wetland Scientists. That's number 101071 is my number, and it's active.
Okay. What professional experience do you have specifically here in Walton County?
So in Walton County, since I've been working, well, I guess my professional experience in the Panhandle started back when I was working for the state of Florida Department of Environmental Protection and Regulation, or first regulation, then protection. At that point, I was a manager, environmental specialist 3 rather, in Tallahassee, and my focus was on rural development for the wetland program, the dredge and fill program at that time. It transitioned into the ERP, or Environmental Resource Permitting Program, later. And the major part of my goal was training, statewide trainer on the applications of the rules and regulations with respect to waters, wetlands, and permitting. Then from that point, I became interested in broadening my perspective and going to the private sector. I started with a firm called Phoenix Environmental Group in Tallahassee. Subsequently developed my own firm, Piedmont Environmental Services. Then I merged with 2 other gentlemen, and we became Basso, Densau, and Imhoff. I was president of that firm also, and now I'm president of Densau and Associates. Together, combined, I have over 40 years of experience in wetlands, wetland regulation, threatened and endangered species, permitting in the state of Florida.
So it's safe to say you have extensive knowledge of the regulatory frameworks that impact wetlands and other environmental areas?
Yes, it is.
Okay, all right. Have you ever been qualified as an expert witness before?
Yes, several times for quasi-judicial proceedings with the Florida Department of Environmental Protection. I was qualified as an expert in dredge and fill permitting and the impacts of dredge and fill permitting.
So at this time, I would like to tender him as an expert an expert wetland scientist.
Can we just say he's an expert in wetlands?
That works for me.
Every time I bring one up,
science,
you'll
okay.
cut it down even more.
Are there any objections?
No objection.
So tendered
Okay, thank you.
and accepted.
Also, let's do his CV. Applicant's Exhibit 9. Is this your CV?
Yes, it is.
All right. Any objections?
Let's see. Exhibit 9 is admitted.
So, Dr. Densau, what has been your experience with this project so far?
My experience has been to provide an opinion with respect to the stormwater ponds as qualifying as a potential conservation element.
And what ecological functions do these ponds serve?
By definition and by statute, Florida Statutes 373, the ponds are designed to provide water quality benefits with respect to, water quality benefits and attenuation benefits, so quality and quantity. So that's the primary function of them. Whether you plant them or don't plant them, plants will come in and they provide habitat, and that's established in literature. The level of habitat that they provide is what's often debated in the literature.
But is it safe to say that the ponds provide food web support?
Absolutely. I've not only observed many ponds, I've planted many stormwater ponds in the Panhandle. They provide habitat ranging from wading birds, as was mentioned earlier, egrets, herons, great blue heron, little blue heron, Louisiana heron, green egrets, down to what those species feed on, which are going to be the fish. So we got bass, smallmouth, largemouth, bluegill, red ear sunfish, things of that nature. And then those fish have to have their food source, which would be the smaller fish, the killifish, using a generic term. And then those fish have to have their food source, which would be the macroinvertebrates, the bugs, so to speak, the arthropods and things of that nature. And then for those to survive, they have to have the detritus and the function forming and a lower food web. So for the birds to be there feeding on larger fish, there has to be a complete food web.
And
present.
you have you've experienced these species using these kind of ponds before?
Many times.
So how do the ponds, how are they consistent with the conservation of natural areas?
So what I focused on for that, and I need to pull out the specific definition because that's not my area of expertise, but I have it on my think so. Yes, there we go. So as I was presented with this to provide my professional opinion, it says a minimum open space percentage of 60% must be provided that it's consistent with the conservation, I want to emphasize that word, of natural areas, environmentally sensitive land, habitat, I'd like to focus on that word, or farmland. This is not farmland. And honestly, in my professional opinion, it's not a natural area either. It's an existing community type that's an artifact of prior land misuse, if you will. So it dates all the way back to the early days when much of the southeast, as a matter of fact, is considered a fire-maintained ecosystem. Basically, what that means is that fire would be a driver in the system that would kind of shape the plants and the plant communities that would be there. So if you look at historic aerial photographs, for example, throughout much of South Walton County, you'll see basically a more of a whitish open signature, which meant that there were very few trees there. Then somewhere in the 60s and 50s started getting more development, starts fragmenting areas up. So fire that naturally establishes with lightning doesn't have as much room to roam and create the mosaic of the habitats that were historically here. And then we have what I like to call the Smokey the Bear era, where fire was bad and there was active suppression of fire. All that leads to a gross change in the quality of the ecosystem, transition from what we call prairies, whether they be wet or dry prairies, to very, very dense thickets of either, if it's a wetland area, tai-tai, which is a T-I-T-I, it's a plant that will cover great areas, or in the case of upland areas and wet flatwoods, pine trees. And in many cases in South Walton, throughout much of the Panhandle actually, we've used these areas and planted them as silviculture for pine plantation. Now, I don't know if these were actually physically planted. There are a lot, they appear to be from aerial photographs, very even-aged trees, which suggests that there is some type of factor that basically prevented the natural fire to come through and allowed the trees to come in, whether they were planted or they came in naturally.
You mentioned aerials. Did you have a chance to review the exhibit? And I'm sorry, I don't remember the exhibit number, and I think I gave mine away, but it's the aerial photographs that we supplied?
I have.
Okay.
So the first one I have is
the judge find her picture first.
Exhibit 7,
Okay, yeah.
if anybody's
So Exhibit
keeping track.
7.
The first one I have is labeled as a 1940s aerial off of North Church Street with the property boundaries superimposed. You can see very few tree cover in that aerial photograph. You see a dark signature on the western side, which is a wetland. You see then spotty trees throughout. This would have been a classic habitat when we had fire-maintained ecosystems in South Walton County.
And what does the 1999 aerial show?
So the 1999 aerial shows the same piece of property, substantially more tree cover, especially in the northern one half of it. It looks to be a completely dominated tree cover. There's a little bit of open space south of that. So at this point in time, the pine trees hadn't had a chance to colonize the entire site and replace the herbaceous plants that were there and represented basically by the 1940s aerial. So we're doing environmental restoration projects and we're trying to restore something. As an environmental scientist, I'm trying to restore it back to 1940. That's what's considered the natural habitat. That's what the agencies consider when we're looking
At this point, I'm going to object for relevancy purposes. However fascinating it is to me, I think we're far beyond the bounds of arguing of open space and going into history lessons of what this used to be, rather than the definition of open space.
Okay.
It goes directly to whether or not this area is actually natural habitat, natural area.
All right, well, I agree that what
A little too much?
I would like to sustain the objection and ask you to just focus his questions on this project and the relevancy of what is natural.
Okay.
If that has to do with something in the past, that's fine, but if you could just focus your questions.
Okay, so if you want me to focus on the project, then I've got to still talk about 1999, because the difference between the 1999 aerial and the 2024 aerial is the crux of, well, in the 1940s, is the crux of why this area is not natural habitat, and that's what I was leading him to testify about.
Okay, but stormwater ponds were not there in 1940 either. So, I mean, if you want to go back, it's your case. I would just focus on what's relevant in the code and in the comp plan.
So based on your review, present day, as the land sits, is this a natural area?
I would not consider it a natural area, no.
Can you expand on that?
Yes, it's an artifact of prior neglect. So therefore, the trees that are there were either planted or came in, and does not represent a historic natural community that we strive for in ecological restoration and protection.
As far as the ponds themselves go, let's move on to that. In your opinion, I think you testified already that they will provide habitat for several different animals. Well, just strike that entire question. Is there any reason why the property owner could not go in and clear cut this property right now for timber harvesting?
Based on my understanding, no, there's no restriction to harvest timber silviculture wise.
I'm just going to leave it at that. So that's all I've got for the moment.
Davis?
I just want to make sure that we're clear on this last point. So, I mean, your expertise is specific to wetlands. Is that correct? So, your understanding of whether or not they can clear cut those that has nothing to do with the land development code and the comprehensive plan. You're strictly speaking from a silviculture perspective. Is that correct?
Correct.
Okay.
Mr. Arline?
Do the state stormwater regulations require that stormwater ponds, state that stormwater ponds are open space?
I'm not aware of that. I have no knowledge of that.
And it's, the state rules on stormwater don't override local regulations on open space, do they?
I have no knowledge of that. It's not my expertise.
You've been following the new stormwater regulations?
No, I have not.
You know whether or not stormwater treatment facilities could be provided underground?
I have no idea.
Or whether they can be dealt with in a filtration system?
That would be an engineer.
You said that the existing site was not natural area, but isn't it habitat?
There is habitat there, yes.
No more questions.
Any follow-up? Okay, thank you for your testimony. Mr. Tatum, you have any other witnesses? Okay.
I'm going to call Curtis Smith as a fact witness.
All right, Mr. Smith, you have been sworn in previously, and you're still under oath for the purposes of this hearing. You understand?
Yes.
Okay.
Thank you, Mr. Smith. You've been practicing in Walton County. We're not qualifying you as an expert, but you've been practicing in Walton County for how many years now?
Approximately 12.
Okay. So have you been involved in or followed the progression of the conservation residential land use?
I have.
Tell me what your experience has been.
So being that I've been in for approximately 12 years, that would have been in 2014, 2015 era when I began working in this area. And I recall back in 2017 and 2018 was when the Walton County Planning Department began a monumental effort to overhaul the Land Development Code and the comprehensive plan. As I was sitting back there, I was actually going through email archives and reviewing. We had a deputy planning director at the time named Kristen Schell. She was the deputy planning director prior to Stephen Schoen, who was here earlier and spoke about being the deputy director for a year. She was his predecessor. I found a lot of the old communications that were through all of the months of 2018 where these rewrites were taking place. I would actually jotted down some notes from those emails. That
I'm going to object. He's offering hearsay testimony. He's offering testimony of what he knows of Michelle's.
He hasn't offered any hearsay yet.
Okay, before you go any further, you've been offered as a fact witness, not an expert. If you want to talk about your experience, that's fine. It would be hearsay to go into emails that you were not a party to, that are not admitted into the evidence.
Okay.
That's not going to be helpful.
I will just ask him direct questions.
Record. Okay, if you'll just focus.
What did the 2017 comprehensive plan policy say regarding conservation residential uses?
So the 2017 comprehensive plan policy, that was section L 1.31, or I'm sorry, L 1.3.1, and then subsection D4. That was where the technical information resided at that time. At that time, most of the technical information in Walton County was in the comprehensive plan, not quite as much in the code, and there were a lot of conflicts at that time. So that was part of the big rewrite. So at that time, comprehensive plan said 40% of the total parcel area may be cleared of natural vegetation to allow access, supporting infrastructure, footprint of principal structure, and all accessory structures, while the 60% of the developed site must be retained in its existing natural state and preserved as open space.
And it's
Okay, I think the objection is to relevancy and how this relates to the current day. I have to apply the current code.
That's correct.
And I understand that there were directives, the two letters from the previous determination. Those obviously are interpretations, but I don't see how this witness, unless he is involved in this project or was involved directly with policy development of the code, I would have to sustain the objections of both the county and Mr. Arline.
So the relevancy goes directly to the intent of the land development code change that occurred. And what has been already put forward in questioning from the opposition and what I anticipate them putting forward in their direct all goes to what was the intent of the current code.
Okay,
which
but
is why
I'm going to be interpreting that. If you want to cite to previous code provisions in your PRO, that would be a proper argument. But I'm not seeing how this would maybe lay some foundation of his knowledge. I just don't see it, and it's getting late in the day. So I'm going to give you another opportunity to focus your questions for this witness. But I think you know what I can interpret, and it sounds like that this is going to come down to me reading the code and figuring out whether.
And I don't disagree with that at all.
Okay, so if you think that he has relevant information.
Well, he does, but I can put it in the PRO.
Okay.
All right.
All right. Thank you.
Anything further?
Unless somebody else wants to cross you on, but it doesn't really make sense at this point.
Is there any cross-examination for this witness?
Just one thing to make sure that we're clear for the record.
Okay, if you'll come back, Mr. Smith.
Because he still
Want to ask him
offered
a
some
question?
testimony
Okay.
at least. So
Yes.
Mr. Smith, at no time have you been an employee of Walton County Planning Department?
No, ma'am.
Okay. So you didn't participate in any rewriting
We actually did participate
from a advisory perspective?
from advisory
But you were not an
perspectives.
employee?
No, ma'am.
Thank you.
All right.
All right,
Um,
Mr. Tatum.
Just reserving time now for rebuttal at the end after public comment. All right, thank you.
Mr. Arline, you are a party, you can put on witnesses, but you know how that goes with the public comment, so.
Yes, I will. I don't know how much public comment there'll be, I mean, but, my name's Terrell Arline, represent the South Walton Community Council. Craig Diamond is our expert witness. We're gonna have two residents from the area, Mike Klein and Tim Asaro, who live in the area, familiar with this whole, issue. Obviously, SWCC opposes the project. I've previously passed out a binder of 5 exhibits, which includes the PowerPoint, Craig Diamond's CV, Craig Diamond's report, some pages from the March 26th Special Magistrate hearing, and the Planning Director interpretations that we've talked about here ad nauseum. And would move them in. We do that.
Talking about?
So I think exhibit number 1 is not gonna be it will not be admitted, but it's obviously.
No, but I would ask for appellate purposes that the PowerPoint that he uses, it does get moved in as a demonstrative exhibit?
Yes, it will be
So-
included in the record as demonstrative, but I will not consider it as evidence in for my purposes of making findings of fact.
Yes, Judge, and my understanding, Exhibit 5 has already been moved into the record, so I would think that it would just be 2, 3, and 4. Has 4 already been moved in? Oh, yeah, that was just gonna be demonstrative as well. Number 4 in his exhibits, I think that was just gonna be a demonstrative exhibit, so,
But yes, we're good with 2 and 3.
yep.
Okay, so I have SWCC's Exhibit 2, which is the CV, and Mr. Diamond's report are admitted into evidence. Exhibit 5, SWCC's Exhibit 5 has already been admitted with, I believe, Mr. Brown, when Mr. Brown testified. So, Mr. Arlen, if you would like to, I don't know if you're finished with your opening, but.
Right. The copy of Mr. Diamond's exhibit that you have, that I passed out in the binder, is highlighted. His unhighlighted copy was filed by the planning staff in the portal. So the highlights are really kind of just for it'll make his testimony easier because it'll help you and him focus on his testimony about his report. So there's 2 copies of his report. One is without highlights and one kind of is with them. But at any rate.
All right, I'm going to ask that you supplement either, I understand things are in the portal, but we've been entering into evidence exhibits. So if you will provide an unhighlighted version of Mr. Diamond's report. You don't have to do it right now, but make sure an unhighlighted version comes in. And that's what we will consider as exhibit number 3.
Okay, I want to present a PowerPoint presentation that's hopefully just narrow this a little bit. And there's a hard copy of it in the binder. It's the first document. So obviously this preserves of Santa Rosa. As you know, it's 39 lots. It's 20.06 acres. Flume designation, residential conservation, zoning, residential, conservation residential. What is this case about? It's about open space. And there's a map of the parcel, and The staff report that was presented and that's in the record says itself that the property is currently vacant and heavily wooded. And attached to my PowerPoint is just a cut from the site plan, which includes, you know, an analysis of what's there now. And then what the proposed plan does is to create these open space areas that includes stormwater ponds. I mean, the 60% open space is going to include these large stormwater ponds. And the focus has been on the glossary's definition of open space, which is the generic glossary of the Land Development Code. The amount of the site that's devoted to recreation, resource protection, amenity, or landscape buffers. Open space may include, but it's not limited to, lawns, decorative planting, walkways, active, passive recreation, playgrounds, fountains, swimming pools, which was focused on by the applicant in their memorandum of law, wooded areas or water courses. So, but that's the generic. That's the broad definition in the code. 2.02.09, as we talked about many times, G1, this says that the minimum of open space percentage of 60% must be provided. And then it says that is consistent with. It doesn't say, it doesn't refer to all of the open space criteria that's in the generic glossary, consistent with the conservation of natural resources, environmentally sensitive lands, habitat, or farmland. So that's what governs this here. That narrower provision of the open space criteria in the conservation residential zoning category that this development is being proposed in. And we've shown that previously in April of 2024, county planning staff interpreted this provision to provide more protection for environmentally sensitive lands than the generic definition of open space provided in the glossary. So that was planning staff's interpretation back to 2024. And that is, we agree with that. That's SWCC's interpretation of it as well. But then in February of 2025, and apparently because of discussions that were had between planning staff and engineers for the developers, they changed the opinion of what the term open space means in conservation residential zones to include wetland detention ponds. Now, Ms. Margaret Landry will testify that, she didn't know about that. They didn't have a public hearing. They didn't have a notice. I mean, it was just something that was done internally in staff. But at any rate, they changed their position and, allowed ponds to be an open space. And this is one of maybe the first project that's come along where, development of the conservation residential has had, such a large amount of stormwater in the 60% open space. SWCC's position is the code says what it says. 2.02.09G, 60% must be provided that is consistent with the conservation of. It doesn't say consistent with conservation uses. So I think there's a difference between conservation of and conservation uses when you interpret this as you are entitled to, and that is an important distinction. And on that point, I want to just draw your attention to the concept of interpretation. Now, I filed a responsive memorandum of law to their memorandum of law. I sent it through the portal. I don't know if you've seen it. I'm not going to get into it right now, but I'm assuming you'll look at it before you decide what to do here.
I'm sorry, I think there's objection.
Not really an objection, it's more just a point of clarity. We ended up not moving, or we never filed our memorandum of law with you. What I it's intended to put in to begin with, and then we decided since we're doing the PROs, there's no point in me putting it in. So she doesn't actually have it and won't see it.
Well, anyway, I filed mine.
Okay, so what I would encourage you also to put it in your PRO, whatever the legal part is.
Right.
Okay.
But, the point I'm trying to make is, in the Land Development Code is section 1.0800, right? It's an interpretation entitled, it's a titled interpretation. And it states in paragraph H1 that the Director of Planning shall have the duty and responsibility to issue formal interpretations relative to the meaning and application of any provision of this land development code. Responsibility for this interpretation by the director shall be limited to standards, regulations, and requirements of this code. Now, this is the important thing for you. And shall not be construed as overriding the responsibilities given to any commission, board, or official named in other sections of this code, chapters of this code. That's you. You're the special magistrate. And so for the applicant to argue that you're bound by this interpretation is incorrect. The LDC says their interpretation doesn't bind you as an official that's interpreting it. So back to the PowerPoint. And this is important, and this is all the perimeteria, statutory interpretation stuff that I'm getting into, and it's laid out in my memorandum of law. But the other zoning districts, other than the conservation residential, discuss open space and allow different uses in open space, okay? And I've laid those out in the memorandum of law, like large-scale agriculture. It says open space must be limited to passive recreation, agriculture, silviculture, resource protection, amenity, or landscape buffers. I'm not going to read through all of them, but the point is that open space and other provisions of the code are broader than the open space provisions in the conservation residential, and that makes sense because you're trying to preserve the conservation values in that property. And in some zoning districts, there's no mention of zoning open space at all. So you get into terms of statutory construction, which you know all about. We think that the limitations on the type of land uses allowed in open space in the conservation residential zoning category control over the broader list of uses set forth in the glossary or other sections of the land development code that have been cited by the applicant. And I cited the Fitz versus First case, 283 Southern 3rd, 833. The court said, this was 2nd DCA, we must turn then to the well-established principle of statutory construction that the legislative use of different terms in different portions of the same statute is strong evidence that different meanings were intended. And that's what's happening here. And that's the type of statutory construction principle that should help you make the right decision. The types of open space in conservation residential are more restrictive than the types of open space in the glossary. It's just simply the truth, and in the other zoning categories. So the open space in conservation residential has to be consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland. That's what it says. It doesn't include stormwater, and that provision should control. I've got a couple of other things that came up during the case that I wanted to mention. Oh, Rinker. The Rinker Materials case. I mean, we've all read that. That was cited by the applicant as meaning that because the code is ambiguous in some way, and we don't agree it is, we don't think it's ambiguous at all, that Rinker means that you got to interpret it in favor of the property owner. Now, on page 12 of my memorandum of law, I cite the Rinker case, and this is what Rinker stated. Since zoning regulations are in derogation of private rights of ownership, words used in the zoning ordinance should be given their broadest meaning when there is no definition or clear intent to the contrary, and the ordinance should be interpreted in favor of the property owner. So you only go down the Rinker rabbit hole if you've concluded that the code, there's no clear intent to the contrary in the code, and we submit that there is. I think those are the main points that I want to make, and we'll get the case going, call our witness.
Who would you like to call first?
Craig Diamond? Yeah, we're done with PowerPoint.
My name is Craig Diamond, C-R-A-I-G.
State your name.
Hold on, let me swear him in.
Oh, right.
Don't forget the basics.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do. Thank you, Your Honor. I thought you were
Bless
gonna
you.
go get some.
Where do you live?
My address is 405 Inglewood, I-N-G-L-E, Wood, W-O-O-D, Drive, Tallahassee, Florida, 32301.
And you're currently retired?
I'm retired, although I'm still on retainer with my last employer, and I get called as needed on basically an hourly basis.
Could you please review your educational experience since high school that's relevant to the issues in this case?
Okay. You said my education since high school?
Yeah.
Okay. I think most relevant is I took a master's degree in environmental engineering science with an emphasis on systems ecology.
At which university?
That was at University of Florida in Gainesville.
Go ahead.
So that was it as far as education.
Okay, what about experience relative to the issues? Briefly review some of the.
Yeah, in terms of work experience, so just to keep the focus only on the issues relevant here, which I'm thinking is still zoning and land development regulations relating back to comprehensive planning, open space, and stormwater management, I'll offer the following limited description of my background. So by choice, beyond working in environmental engineering sciences, my master's coursework also did include programming in urban and regional planning. I worked for several years at the Center for Wetlands at the University of Florida, including numerous wetland studies throughout the state, a landmark wetland study of Seminole County, which included as part of the assessment of wetlands and wetland conditions there, scripting land development regulations to protect those resources. I did a lot of ecosystem monitoring, vegetation studies, water quality assessments and the like, primarily related to phosphate mine reclamation, but it did include other sorts of wetland context. Following that, I served as a research faculty in the state university system. Following the adoption of the Growth Management Act, and the office where I worked was effectively Growth Management Central. So most of my work focused on local government planning processes, and plan development. Specific projects during that time, as related again back to this project in question, I was funded by DER, now DEP, to conduct the first survey of stormwater utilities and the functions therein. And I supported the Florida Stormwater Association in follow-up surveys after that. I did research and was invited to write a book on open space and conservation easements. And I served as a faculty with the Lincoln Institute of Land Policy for, I guess, about 18 months, and convened a Florida conference, or a conference in Florida for the entire Gulf Coast region on open space protection and conservation subdivisions. I later worked 12 years as an environmental planner in local government, supervisor in environmental planning, and as special projects manager for Tallahassee, Leon County Planning Department, effectively 2 separate local governments supported by 1 planning department. It was not my primary responsibility to do site plan reviews, but I certainly did a number of them and would have been consulting with staff, meeting with developers, looking at site plans, proposed applications, and also handled customer review where developers would come in and look for floodplain determinations, want to understand more clearly development regulatory controls. And I also served, the Canopy Roads Committee was under my section that I was responsible for managing, that looked at all development, commercial and residential, in narrow corridors throughout Leon County. A big portion of my work was related to open space and greenways protection, including land acquisition, and a lot of effort on comp planning policy writing and associated LDRs for those specific things that were primarily environmental. One of the other things I had responsibilities for were EARs, evaluation and appraisal reports. These are required of local government to review their own planning processes to make sure that they're on track and to follow any changes in state regulation. So I managed 2 of those environmental and appraisal processes for local government. And I also work with both city and county public works departments on stormwater projects. And that led to supporting an additional effort as a separate quasi-independent agency in Tallahassee, Leon, referred to as Blueprint 2000. That was responsible for additional greenway and open space protection as well as stormwater project implementation. And I also worked on a number of comp plan policies and LDR revisions and amendments during the time I was there, specific to lake protection. I had worked 3 years as a water resources planner with the Northwest Florida Water Management District. Part of that scope of work certainly included review of comp plan amendments and LDRs that would have had any impact on water resources throughout Tallahassee, Leon County. Well, I take that back, throughout the entire region of North Florida Water Management District. My last job was relevant here, was as chief of state planning, overseeing 26 staff in multiple sections that provided direct support to local government in numerous areas of local planning. Natural resources protection was the focus of a single section. Perhaps maybe more relevant here, I would offer that I oversaw the section dealing with areas of critical state concern. Walton County is not in an ACSC, but as the other half of DCA's work was really only at the comp planning level, comprehensive planning level, the area critical state concern program actually looked at any land development regs and looked at and approved, or not, all site plans being submitted in those special areas of the state.
All right, Mr. Tatum, do you have?
In the interest of time.
Okay. Yes, sir. Okay.
What are we qualifying him as?
I would, he could go on, Your Honor.
All right.
I also have his CV that's been admitted into
Okay,
evidence.
I would qualify him as an expert in land use planning, qualified to render an opinion as to whether the proposed development in this case is consistent with the Walton County Land Development Code.
Your Honor, I see in the CV, it specifically says that he's been qualified in other DOA hearings as an expert in environmental planning, comprehensive planning, wetland science, water resources planning, and water resources science. So I would have no objection to him being qualified as an expert on those bases.
Okay. Can we?
And I have no objection to him being qualified as a land use planner.
Thank you.
Qualified. Well, we just,
Well,
since we're not putting qualifications
not
on
a
anything, he's a
planner.
land use planner.
Land use planner, I
Thank you.
believe that we also have an expert that Mr. Tatum, you provided in wetlands, so, is that right?
I'm sorry, I didn't understand your question.
And I can't remember his name,
Dr.
yes.
Denzel?
Yes, that he was qualified as a wetland
That's right.
science.
Mhm.
I believe that Mr. Diamond also has been qualified previously in wetland science. Is that Mr. Arline?
Yes, Your Honor.
All right, so I would consider him an expert and allow him to testify regarding planning and wetlands.
Thank you, Your Honor. Now let's get into the details. Did you do a site visit here?
I did.
And what did you see that is relevant to the issues in this case, if any?
Well, cursory view, and I did certainly look at aerial imagery, although not the ones that were presented just this morning. From the edge of the property, we were not interested in trespassing, as from the edge of the small filled pad at the south side, on the south parcel, it looked like, at this point, classic pine flatwoods. There were a number of other wetland hardwoods in there, magnolia and bay. Obviously not conducting a full site visit. It is natural habitat. I don't dispute Dr. Denzau's taking that it is property that's been in transition for a whole host of reasons, but it functions as natural habitat consistent with pine flatwoods characterizations throughout this part of the state.
Okay. And generally, briefly review what you did to prepare your testimony here today. Did you review the Walton County Planning Department files on this project?
Yeah, the ones that were available at that time. So I believe in my submittal, there was a list of probably 6 or 7 documents. So certainly the Walton County Comprehensive Plan and the Land Development Code, both of the director's interpretations. I'm trying to remember what else was part of that list. I did look at the glossary. I also included, as the defendants note, that the APA glossary was also used as a reference. I looked at the ERP,
You said defendants, do you mean the county or the applicant?
the applicant, I'm sorry.
What is the APA documents you looked at? What does APA mean?
The American Planning Association Dictionary.
And why'd you look at that?
Well, you know, we're teasing a lot of words apart here. Not every word in the Land Development Code or the comp plan is uniquely defined or maybe sufficiently defined to avoid some of the challenges that we've got. This is, at the end of the day, still a planning case, and the APA provides something on the order of 4,200 definitions that are broadly referred to by professional planners to assist them with writing plans, with writing codes, and applying them. And again, it isn't definitive. It provides lots of examples from other jurisdictions, but it's helpful to understand what the general parlance is of planning and how these words would at least be initially interpreted, unless otherwise clarified or recharacterized by the local context.
Did you look at the new agenda packet, March 26, included updated director's interpretation February of 2025, I think?
Yes.
And looked at the plans that were in the agenda packet?
Yes, I looked at the plans that were in the previous agenda packet as well as the updated submittal.
And this resulted in a written report of your work and findings?
Yeah, the written report was, as noted by others, was largely cut and paste of the relevant pieces of the LDC and the comp plan and the other documents that were reviewed, and then followed by my initial reactions and opinions about how they all squared with each other.
Well, given the time, I'm not going to go through this whole document, which is, 30 pages. But I do want to, if you can, focus your opinions and your documents and your report on the issue of whether open space in this context, the conservation residential zoning category, should include the stormwater ponds that are on the site plan. Can you narrow it down to that?
I can narrow it down very simply. As I read the Land Development Code and the context, the broader contents of the comp plan for which the LDC is supposed to implement it and further it, the intent language is plainly there, that the purpose of the conservation set aside, the open space set aside in the conservation residential categories, of which there are 3, was intended to preserve, and we don't want to get into fighting about that, but certainly to set aside, in this case, 60% of the property, which is for natural areas, habitat, and environmentally sensitive lands. And we can leave the farmland issue out since that's not really relevant to this particular parcel. So it's clear from the reading of the language to me, trying to look at the entire package as well as both the intent of what's offered in the descriptions of the land use categories, and then putting that in the context of, is it treated differently anywhere else? The intent is that the 60% is to be protected through some measures, and the remaining 40% may be developed. And the issue of whether stormwater ponds are in there or not, it's apparent to me that the intent is that all development, both the development of interest, in this case residential lots, the roads, the utilities, the infrastructure, and everything else, is intended to be accommodated by the 40% that's not set aside. I think that's really, really plain from the language. I'd have to go back and check
do you think a stormwater pond is infrastructure or?
For the purposes of this characterization of open space, it functions as infrastructure. The other testimony made clear that its intent is for flood diminution, to avoid impacts off-site, and for water quality improvement. And that's all directed for the benefit, if you will, of the development in play. No one's building stormwater ponds to go ahead and protect other properties off-site. It's being done to mitigate the impacts of the development on-site. And again, it's consistent with the notion that any particular development that comes through needs to have the necessary square footage to accommodate all the individual components to support the scale of the development in question. It seemed really clear that when it mentions utilities and infrastructure, and the state's own definition of even wet detention ponds is it's not natural, it's not open space, it is referred to as man-made system to support the functions that have been talked about by others. It is in effect infrastructure. It can be nice, it can be aesthetic, it may provide, if managed appropriately and sited appropriately and maintained, it may provide some additional potential benefits to the community, but it's still infrastructure. It's providing a unique water quality, a required water quality service to avoid downstream impacts. That's why the state requires them. It is not open space. It is not natural area for the sake of natural area, because it represents an immediate transition from what's already there. The language in CR 2-1 is clear that the intent is conservation of the right resources on site. It doesn't say displace the resources on site and put in something else that's maybe some other type of habitat. It sets numerical standards on how much land is expected to be allocated to either.
Wait, let me.
Go ahead.
We talked about these two director interpretations. One's from April of 2024 and one from 2025. Which one do you support as being consistent with the Land Development Code?
The 2024 memo is clearly consistent with the intent of the comprehensive plan and the implementing Land Development Code for conservation residential.
Now, the one that was issued in 2025 was an amended interpretation. Do you agree that with that conclusion, the planning department, that wet detention areas are authorized in open space in the conservation residential category?
No, thank you for clarifying. Within the CR category, it's clearly not.
And you read in the 2024 interpretation, the second one, where the staff is talking about entitlements. What does that mean to a planner?
Entitlements would ordinarily refer to the number of units that, or the total amount of square footage that might be imposed on a property, subject to the zoning in which it occurs.
Do you think that looking at this 20-acre site that is zoned for residential, that a development could not occur there that had no homes on it, or could not be developed with any residential structures?
Well, clearly there are other lots nearby of similar nature. You know, the area is carved up into 10-acre lots in the large part, and a number of them have single-family homes or single-family homes and an outbuilding on them. I don't know whether any of the second buildings have got kitchens and bathrooms or not. You know, it might be a secondary unit consistent with the 1 to 2.5 zoning category, which largely surrounds the parcels in question here, which would allow them hypothetically 4 units on a 10-acre lot. But no, there's really nothing to preclude anyone from building a unit on the 10 or the 20 acres that are in play here.
Meet the open space requirement.
Easily.
Now, did you review the glossary and that term, the definition of open space that we've talked about here?
Yes, I did.
Do you think that controls over the conservation residential open space criteria?
No, because that paragraph 2.0209G is a special development characteristic or a special development requirement. It's unique to the zoning code. It sets forth the specific provisions that presumably are to enforce or further the intent stated the general purpose of that zoning district. What's that district supposed to do? It's supposed to conserve and protect the resources that are on site. The glossary, as was noted by others, provides a much broader definition, which may well be applicable in other zoning districts. That's easily enough said. It was clear to me when looking at other parts of the code, For example, there's a greenways provision. Now, this property is not in a greenway, but the greenways land use category and zoning concept allow for regional, not on-site, regional stormwater facilities, including wet detention ponds.
And open space.
Yes, yeah, because they're intended to be large-scale linear corridors to provide multiple community objectives.
Why doesn't that govern this conservation residential zoning category issue?
Because it's a different zoning construct. It does not apply to the CR. They're totally separate zoning realms.
And in your review of the land development code and other zoning categories, are there other discussions of open space, various other land use categories?
Yes, and they do not include the specific characterization that the purpose of the open space to be set aside is that unique direction of supporting or preserving the resources on site. Again, the habitat, environmentally sensitive areas, and wetlands, et cetera.
Now, there are 3 categories in the land development code of conservation residential.
Yes.
They're cited in the, but each one of them has an open space requirement, right?
Yes, the 1 unit per 10 acres is 90% set aside, and then there's the 1 unit per 2.5 acres has an 80% set aside, and this, the most highly developed of the 3 with 2 units per acre, has the 60% set aside. But I would add that they all have got the same qualifying language, so it's all under the conservation residential future land use construct. And
they all have the same definition, they all have the same open space requirement that must be provided that's consistent with the conservation of natural resources, environmentally sensitive habitat, farmland, right? All those other.
Yes, they mirror each other. They use the same language to enforce that notion.
So in this situation, if we were to conclude, or if the special magistrate were to conclude that stormwater was allowed in open space in the conservation residential district here, would that affect what could be allowed in the open space in the other conservation residential zoning districts?
I would imagine it would. Once that door is open, there's nothing to preclude reconsidering the disposition of any of the conservation residential categories, because they all have got that same qualifying language.
On page 19, 20, and 21, you outline your conclusions to encourage things to move along here. Do you adopt the conclusions in your report as your testimony here today?
Well, yes. Yeah, I didn't have any changes to them. And in the interest of time, I won't prefer to add extensively to that.
Some of them you've already discussed, right?
Yes.
Let me ask you, as a professional planner, do you have an opinion as to whether the county staff's interpretation set forth in the 2026 director's interpretation, which supported and recommended the approval of this development, is reasonable or unreasonable?
I think you meant the 2025 one. No, I think this
2025, right?
We've discussed this before. I think it was a misapplication of the existing provisions of the code and the comp plan. It was a stretch to make that happen, no, I can't conclude that that's correct.
And can you conclude on the same logic that the development order that's proposed in this case is not consistent with the land development code?
I would offer that it is not consistent.
Just trying to go through my questions to save some time, Judge. I appreciate the. Okay. Is there anything that you mentioned in your report that we didn't flesh out here for the judge that I skipped over?
I would just go ahead and emphasize that as a reader and as a planner that have to deal with multiple jurisdictions across the state, and they're all different. And you know, the opportunities are there to interpret differently in accordance with what's put in front. And it just seemed that when you look at the comp plan as a whole and the land use code as I don't call it a supplement to it, but it's the vehicle by which the vision of the county is put forth. There's ample language in the comprehensive plan that makes it clear that the county's broader purpose is, where appropriate, to go ahead and preserve properties that are more or less in natural condition, at least undeveloped. And there are different zoning categories to implement that, and they implement that differently. And at the end of the day, this CR category is unique in terms of what it expects. The list of intended uses is quite small. It's fully consistent with the comp plan, broader vision for the county as a whole to preserve what it can. And the CR, again, fleshes this out in a very unique way for a narrow subset of uses that don't apply everywhere else. And with that in mind, the label open space is intended to be a clear set aside. It's the property that's not developed, and I can't look at a stormwater pond as anything other than development. It is infrastructure. I'm not opposed to stormwater ponds. I work with them, have helped design them and everything else, and they have a very critical function. The real question is, where do you put it? Is it in the open space that's to be set aside, or is it in the developed area to service the impacts of the development? And I would emphasize that the plan as a whole and the LDC and the other documents that you've all had placed in front of you place ample weight that it's intended to be incorporated into the 40% of the developed area of the site. There are provisions in the code that specify you need to accommodate infrastructure, utilities, the development itself on the developed portion, not in the open space portion. I'll let it go with that, unless you had any other questions.
No, thank you.
Okay.
You stand there, you're going to be cross-examined.
Yes, I imagine so.
Ms. Davis, do you have any cross?
I do not.
Mr. Tatum?
Briefly as possible. Mr. Diamond, nice to meet you.
How do you do?
So you testified that you did visit the site, or at least stand around the perimeter?
Yes, I stood around the perimeter. It is different than the sites next door, at least to the north. And yeah, it is apparent that it is pine flatwoods. The water table is quite high just from looking at the water level in the ditches. It looked pretty saturated beyond the edge of the pad and fill that had been placed there a while back.
And did it appear to you that, at least on a portion of the site, that the pine trees were in a pretty straight line, indicating a pine plantation?
Here and there. I did look for that. Again, it's much more dense than the parcel to the north that I had paid a little bit more attention to. It may well have been silviculture, and maybe pieces of it had been thinned out. I don't know the history of the site.
You testified this is a planning case, which don't disagree with. I think it's actually a statutory interpretation case. However, are you AICP certified?
I am not.
Okay, all right. But you were, what was your title at DCA before it met its demise?
My last title was Chief of State Planning.
Chief of State Planning.
So
okay.
AICP was not required for any of my planning positions, including being faculty in an urban and regional planning department.
So as Chief of State Planning, did you or anyone in your staff issue interpretations of the statutes or the administrative code?
Absolutely.
Okay. And whenever you issued an interpretation, an applicant for whatever particular, the comp plan amendment or something, they were expected to comply with whatever interpretation the agency had issued, correct?
Generally, unless that got challenged, yes.
And was there a process at the DCA for challenging an interpretation?
No, it would go to a DOA hearing.
Exactly. All right. So are you aware that there is a process in Walton County for challenging a director's determination?
I'm not familiar with it.
All right. So you wouldn't know if South Walton Community Council had ever challenged one or not. That kills that line of questioning.
Sorry.
So you've testified that, in your opinion, the 2024 interpretation is correct. The 2025 interpretation is wrong.
Yes.
But two different director's determinations had to be issued as a result of the language that is in the Conservation Residential Zoning District. Two different conflicting interpretations. Is that correct?
I'm not sure I caught the question in there.
So the question is it not true that because of the language in the Conservation Residential Open Space Regulation, two different and conflicting director's determinations were issued? Is that correct?
There were two conflicting opinions, yes.
Okay. So
At least the final conclusion specific to wet detention or stormwater ponds being an open space. There were a number of other conclusions in the second one that were consistent with conclusions in the first.
that is true. So it's fair to say a reasonable professional planner who's reviewing that section could reach the conclusion that stormwater ponds were consistent or weren't consistent. Is that correct?
If all they had was the second director's interpretation, that is what they would have to work with, at least at first.
But you did have two different determinations that were made. So is it fair to say that the language that's in that Land Development Code section is ambiguous?
I would not say so. I'm sorry. I realize that there are two disparate opinions, but it's not because of
Why don't you
ambiguity.
wait for a question?
Yeah, let's just talk about 20209G1, which is the open space provision. Now you agree, we all agree what it says. Must provide 60% open space consistent with the conservation of natural areas, environmentally sensitive lands, habitat, or farmland. That's the complete text, right?
Yes, sir.
Does it say anywhere there that sensitive lands, environmentally sensitive lands, habitat, farmland, natural areas must not be disturbed?
No, obviously, if you have, say, in this case, 20 acres of natural habitat, regardless of characterizing the quality of it, the expectation is you're going to be disturbing 40%.
But does it say the other 60% can't be disturbed? In the language of the Land Development Code section.
Well, it says preserved, right? Or conserved, I'm sorry.
It actually says consistent with the conservation of. It does not say cannot be disturbed.
No, it does not say it can't be disturbed, and it may well need to be managed. Say, for example, you had an invasion of exotic plants that, were affecting listed species on site. You may certainly authorize or want the property owner to have the opportunity to go in and remedy such a situation. So it's not like no one is suggesting that we put a big yellow ribbon around it and nothing ever happens except
All right, Mr.
natural
Diamond,
succession.
I don't mean to cut you off.
Please.
But if you would just answer the question.
I thought I had.
And Mr. Tatum, if you would.
Move it along.
And not let a narrative
Okay.
across.
All right, let me see if I can. So nowhere in the open space provision does it talk about what uses are allowed, right? That's correct, right?
It says conservation of those three features excluding farmland. I mean, that's the language. That's what's intended.
But as a planner, do you consider as a planner natural areas, environmentally sensitive lands, habitat, or farmland as uses? Farmland, maybe I can, so let's leave farmland out. But environmentally sensitive lands, natural areas, and habitat, are those uses?
I refer to them as dispositions or land character.
All right. So nowhere in that provision does it say what specific uses are allowed or not allowed in the open space areas.
It does not specifically say that.
All right. So it's fair to say that to determine what uses are allowed, you have to look at the open space definition through the lens of 20209G1.
I think the through the lens is critical.
Okay. All right.
And it seems that there's a willingness to go ahead and ignore that lens when we recognize that the open space definition is in fact broader.
So kind of beating the same horse here. Now, you testified that stormwater ponds are development, and because they're development, they should not be allowed in the conservation residential open space. Is that what you said earlier?
I did not say in the open space.
Yeah,
Yes, correct.
All right. So let's say there's a landowner, has a degraded wetland on a conservation easement, or I mean, on a conservation parcel, and he wants to restore that. Would that not require development because it's land disturbance?
Can you say it one more time, please?
All right. Let me give you a different example. So you have a land manager, and he wants to control invasive species in his conservation easement. You've already testified that you believe that would be allowed if they go in and clear it, right?
Yeah, that's different than a subdivision.
All right.
I mean, that's property management. There's a little bit of a difference here.
But I think the difference that we're getting to is you're classifying stormwater ponds as development because there's land disturbance. I mean, that's what I heard you say, is that?
Yeah, the LDC is very clear in terms of what development is. There's a long list of features that characterize digging a hole, whether you plant it with a littoral zone or not, is development under the terms of the LDC. It's not leaving things in place untouched.
Right, as would controlling invasive species, restoring a degraded wetland.
I might disagree with that. I mean, it depends on what's being done. If you're going in and literally manually hacking out an invasive species, and again, we're getting way afield here, isn't development because you're not necessarily digging things up and you know.
But to the extent that it requires land disturbance, it would be considered development, I believe.
There's a scale issue here, and there's a percentage issue that is prescriptive.
So, let me ask you these questions. The applicant submitted his project in compliance with the February 2025 director's determination. You agree with that? The director had the authority to issue that interpretation. Do you agree with that?
I do believe he had the authority to issue it.
Okay. And you've already testified you are not certain about whether or not there is an appeal process. So you cannot be aware of any appeals. Sorry, I'm speaking out loud, but I'm just trying to get this through. And just for record purposes, and I know you don't, but you don't have a Florida bar member, correct?
No.
So interpretation of statute is not something that you're qualified to do, but you can speak to what you feel like that provision means in your opinion. Is that correct?
I disagree. I think the responsibilities I've had as you know, for example, Chief of State Planning, is that we certainly would rely on General Counsel's office as needed, but staff there relied on statute and rule frequently without being attorneys.
Well, I can't really ask you a question on what I would like to say, but it will be in the PRO. So I don't think I've got anything further. Thank you.
Thank you.
Mr. Arline, you have any follow-up? All right. Okay, and I'm gonna, if we can take a 5-minute break. You have to come up to the mic if you want it on the record.
I'm gonna try something that I think will work, and all you have to do is read it. There was a planning commission meeting on this item a couple weeks ago. And
This project.
yes, and in that item, the chairman of the planning commission made a statement on the record essentially agreeing with our position. And she said that she was an engineer who'd worked with stormwater in detention. And I would like to introduce the transcript of the hearing for some evidence that the official for the planning commission agreed that stormwater ponds were not allowed in the open space.
Is there any, you would like to admit this into evidence?
Yes, the
It's the
transcript of that hearing.
And,
It's a discussion on page 34 and page 35 of the transcript.
okay, and
Caroline, are you bringing in the entire transcript or just this portion of the hearing?
I mean, I've got it transcribed, it's only about.
At least, Judge, I have no issue with taking a portion of the hearing and adding the transcript. However, I would like to see the certification or something along with this. I don't doubt, the authenticity of it, but I think it needs the certification page or something to show that this is true and accurately reflected. Whole thing.
okay, so what I have is I have a 41 page transcript, and it has a certificate of the reporter on the end.
It's a little black binder, yeah, that's right
That's what
there,
I
it's
have.
transcript.
Okay, then
And-
I would agree with the entire thing. I think he's just asking to direct to page 34 and 35 of that transcript.
Okay, and because we have the complete thing, if another party would like to include other portions or reference that, you can reference it in your PROs.
Is this gonna be,
I'm gonna mark this as,
or opposition exhibit, 9?
I
or
have
no,
SWCC 6.
6? Okay.
Your Honor, SWCC would call Tim Asaro, our last witness.
Hold on. Tell me your name again.
Timothy Asaro.
Spell your last name.
Asaro.
Mr. Asaro, you'll raise your right hand. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth. Okay. Mr. Arlen, whenever you're ready.
Thank you. State your name
Timothy Asaro.
and where do you live?
I live in Nelly Drive, just by Chat Holly,
Is this close to the site of the proposed preserves at Santa Rosa development?
in the same neighborhood.
Do you drive on that road?
Yes.
Are you a supporter of SWC?
I'm sorry, can you tell me which road?
Which road do you live on?
I live on Nelly Drive.
Nelly Drive.
And is the project on, what road is the project on?
I don't know the exact road that it's on.
Do you,
Church Street, I think.
right, do you drive in the area of this proposed project?
I do, and I drive down Church Street every day.
And how long have you lived in your house on Nelly Drive?
About a year now.
And did you build it yourself?
I did.
You're a certified contractor?
I'm a state certified contractor, yeah, for the state of Florida.
And how big is your lot?
Half acre.
And did you have to come to the county to get permits and stuff to develop it?
Yes,
Is your property zoned conservation residential?
it is.
And so when did you go get your permits?
Those permits, I think that we got them in like maybe 2023 or 24.
Did the county impose any limitations on your ability to construct your house on your half-acre lot?
Yeah, I wasn't familiar with the zoning, so I called and they told me specifically what I could and couldn't do.
Who did you call?
I called the planning department.
And what do you recall they said?
They said that I couldn't touch 60% of the land.
So you wound up building your house on 40% of your half-acre lot?
Yeah, I had to submit a site plan that only included removing 40% of the vegetation.
Are you familiar with the area, the development in the Chet Holly area around your house in this subdivision?
Yep.
This proposed subdivision?
I live there and I have direct firsthand knowledge of the surrounding property zoning and how development has historically been allowed to occur in that area.
Are there any other 39-unit or multi-unit subdivisions in the Chet Holly area?
I don't know of any other 39-unit subdivisions.
What is the existing development out there like?
The existing development is low intensity and consistent with the conservation residential standards. It preserves significant native vegetation, limits clearing, and is designed around natural characteristics of the land. It's not characterized by full-scale clearing and the engineered subdivision infrastructure replacing natural areas. They are primarily just large wooded lots with a single home on them.
Are there 10-acre lots out there with just a single-family home on it?
Quite a few.
Quite a few. Did you make your arguments of what you just said today to the Planning Commission in February?
Yes.
Do you believe and supports SWCC's position that stormwater ponds should not be included in the open space of conservation residential?
I do agree with that.
Why not?
Because
Why do you? I'm sorry.
Because it does not meet the requirements or intent of the conservation residential zoning.
Objection.
What's the
The code-
objection?
He's not qualified
Wait.
to debate that.
In my opinion, because it does not meet.
Let her resolve
Hey, hold on,
the
hold
objection.
on. You're here as a fact witness, so I would limit the questioning
Okay, I'll
to
withdraw the
factual
question.
issues.
Thank you.
I don't have any questions for this witness.
Mr. Tatum?
One, possibly more. Is your property located at 912 Nelly Drive?
It is.
Okay. So if we went out there today, there would be 60% of that property that has been completely undisturbed?
There was some of it that died after we cleared it, and so it's changed because
But you
the
cleared it.
canopy. No, the canopy is gone, and so some of the lower vegetation has, in the area that I intended to just leave alone, it's died.
Where did you place your stormwater facilities for your house?
That's a good question. I had to put them within the 40% of allowable space, which severely limited how much I could expand. So I've got woods that are about 4 feet behind my house.
Okay. All right. That's all I've got.
SWCC rests.
Okay. All right, so is there any rebuttal you wanted, rebuttal after public comment?
That's correct, Your Honor.
I think we're gonna.
And I don't even know if we're going to do rebuttal. I think since we're doing PROs.
Okay,
then-
all right.
We're not gonna do closing.
Okay, the SWCC has closed. Are there any members of the public that don't belong to SWCC that would like to make public comment? All right. Hold on, just so, I need your name for the record.
Michelle.
Hold on. Your name and your address, and then you're gonna be given 3 minutes. I don't know how this works.
I don't need 3 minutes.
Okay. Okay, so,
Michelle, Michelle, Robeson, Robeson, 186 Seclusion Way. 459. I just wanted to say quickly, in reference to Mr. Tatum's point that nobody in the community had objected to this director's determination, we were not made aware of it. It was done without any public announcement. It wasn't announced through planning. It wasn't announced by the county commissioners. We were first made aware of it when we heard about this project. So that's why had we known, we would have opposed within the 30-day procedure, like he was saying. So that's why we didn't until now.
all right. Be careful, you don't have to run. again, if I can get your name and address for the
My
record.
name is Ellen Cannella, Cannella. Address is 1103 East Nursery Road. I live in the Chat Holly area. I don't believe that stormwater ponds should count as conservation open space. I would request that you uphold the recommendations of the Planning Commission and deny this request. Thank you.
Anyone else? All right. At this point, that will conclude the public hearing on this project. As we discussed before, I believe the parties have stipulated to extending the deadlines in order to file proposed recommended orders. I believe that you can upload them to the portal. How would we like to do that?
Your Honor, the way that it was done the other time that we did this, what happened was the proposed orders were emailed to myself, opposing counsel, as well as the judge that was overseeing that case.
So we'll do it the same way. What I would like you to do is just make sure you CC everyone else when you submit your proposed recommended orders. I'm assuming that you can do it within the page limits of that other DOA hearings, which is 40 pages, I believe. That's it. So let's get a date though so everyone knows.
Would we prefer, so the 26th is going to be a Sunday, so we can either do Friday the 24th or Monday the 27th.
Okay, we're saying April the 27th.
Right.
Okay.
So 31 days.
No. I'm gonna give you after we go off the record. I'm gonna give you my assistant's email address, and you can send it to her. And I would suggest that I'll let you do it yourself, but if you put it in Word, it's probably easier for me. But if you'd like to submit it in some other form, you can as well. But the date that it's due is by 5 o'clock, April 27th, 2026. And then my understanding is that I will have 30 days. Okay.
5 o'clock Central Time.
Oh, no, our office, it's actually will be 4 o'clock. So my assistant will be gone 4 o'clock Central Time.
You know how it works, so we extended the deadline, you can extend the deadline.
It looks like 30 days is Memorial Day, maybe? Oh, no, it'll be the 27th, yeah, okay. May 27th is when I should have my order out, or before. If the parties need an extension to file their PROs, please confer with each other. I'm happy to give you extra time. Otherwise, I'm not sure how we get motions, if they file them in the portal, they don't file them with DOA, but we'll work it out. All right. Are there any other questions regarding the PROs? All right. I appreciate everyone's patience and professionality, and we'll conclude the hearing. Thank you. We'll go off the record.